application for restoration.
Matters under the heading for orders. Item number 16.
Gone through the IA? Have you gone through the IA?
My lord, I may be pardoned, my lord. My lord, I may be pardoned. They have filed an IA. Item 16, my lord.
They have filed an IA, but they are not there. So I'm asking the State Council if they have got any instructions about the IA. So let them get instructions. We'll take it up next week.
Yes, my lord. Yes, my lord.
Yes, Mr. B. Vaisar, Learned Counsel for the petitioner. Who will argue the case?
Mr. Rasim.
Place for a passover for considering the fact that the IA. When did you file the IA?
4th November. It was filed on 4th.
Considering the fact that the IA has been filed recently, time is 1 week time is granted to the learned additional standing counsel, Ms. Aishwarya Das, to obtain instructions. There's some earlier IAs also.
Yes,
So
Can it be, my lord? 2 weeks.
Yes, on 26/11/2024. Yes.
Item 17.
My lord, can we submit? Can it be on 28th, my lord? There is little
What
income.
is the problem? 26th. But it will be
My
taken.
lord, Mr. Patnaik is
I am for the opposite part number 8, my lord. 28th, my
Okay,
your
20.
lordship.
But if the petitioner comes and asks for the previous date, we'll give it. If there is no problem, if the petitioner doesn't have any urgency, then it is all right. Okay, 28th.
Yes, my lord. Grateful, my lord.
Item 17.
No, the delay of 234 days. Delay of 234 days. The expense is certified copy. I've applied to 1 week time more in the
Just you have challenged the order. Why have you challenged the order? On what ground? It has been stated that you were not did not get a chance to file the counter affidavit. Case was pending since 4 years. So, what is the ground that you were not given a chance to file counter affidavit?
After they will file,
Who is they?
within 1 day will file. 1 week will file.
What counter affidavit? I'm asking about the writ petition which has been disposed of. How can you file the counter affidavit in the writ petition now? One of the grounds in your writ appeal is that we were not given a chance to file the counter affidavit. So, case was pending since 4 years. You've not gone through the brief.
Yes, yes, I'm briefly there.
Then
I'm taking it that at the time of admission, we have not been hired.
why your counsel was not present?
Vijay, but at the administration date of disposal.
It was always taking the chance that we not given a chance. Yes.
Maternity to grant of pension by a county job contract. Similarly, which SLB pending.
SLB is pending.
Right.
Could you please give us the decision of the because that
Nityananda, same.
No, but Nityananda is not an original judgment. It is based on some judgment of the tribunal. So give us that judgment. All right.
My.
Sudhanshu Shekhar Jaina, same.
My lord, batch pending.
Mr. Das, Sudhanshu Shekhar Jaina relates to job contract. Job contract period to be, so give the order in Sudhanshu Shekhar Jaina. Give.
That was right.
Because all these orders are there, Nityananda Biswal and everything, I find Nityananda Biswal is based on another decision.
All Orissa settlement.
Based on decision passed in TA 11 of 1993.
My lord.
Where that judgment is not there anywhere.
I have to write judgment, but just now I have to.
So we're keeping it next week, you please get that judgment.
Clean over my.
Mr. K.C. Karal, an additional government advocate, undertakes to file the certified copy of the impugn order within 1 week. Considering the said submission, the IA is disposed of. The certified copy shall be filed within 1 week as undertaken. List the case on 26/11/2024. Mr. S.C. Sahu,
Well,
Learned Counsel appearing on behalf of the respondent, will produce a copy of the judgment passed in PA 11 of 1993. A copy of the judgment dated 21/10/1994, passed in PA 11 of 1993 by the Orissa Administrative Tribunal. Full stop. He submits that this matter is similar to WA 194 of 2023, and this matter is also before the Supreme Court in SLPC number 2146 of is pending before the Honorable Supreme Court in SLPC number 2146 of 2024. Bracketed State of Odisha versus Sudhanshu Shekhar Jaina. He is also required to produce the order passed by the Honorable Supreme Court in the said case. Yes. So it will come up on 26th. All right.
Item 18.
In item 18, there has been a delay of 126 days.
Yes. It is that Mr. Sahu was to satisfy how this matter is covered by Malayalam Sethi.
Yes, my case is really covered by Malananda.
Yes, tell us how.
Yes,
You brought the
Yes,
decision
you
in
were
Malayalam Sethi.
Malananda City's case.
Yes, please give us
Because
that.
I am-
Please give us that judgment.
What has been held in Malayalam Sethi?
Yes, it was held, paragraph 7. Paragraph 7, the relevant portion. Thus, from the aforesaid, it can be seen that there was no fault or delay or negligence on the part of the applicant at all. He was fulfilling all the conditions of appointment on compassionate ground under the 19.
So whether Malayalam Sethi lays down a law that's rule applicable as on the
That
death
was not
of,
decided.
that was not.
even decided. Subsequently, what was held.
So that aspect has not been decided in Malayalam Sethi, you agree?
Yeah, yes, your lordship is right.
All right.
So thereafter, it was held that I am reading the paragraph 7. For no reason, his application.
So you are
was-
not relying on the facts, you are a law, you are relying on the fact in the background of which the application was allowed.
In the law also, I am eligible to get. In law, the Supreme Court decided in 3 benches that at the time of scrutiny, the law prevailing will be applicable. That is also applicable. That is also covered to my case, because my scrutiny was done in the year 2010. By then, the new rule has not come. New rule came in the year 2020, but my case was scrutinized and approved by government in the year 2010 or 11.
Mr. Sahu, your father died in 29/11/1995. You have applied
Not 95, 2005.
2005. Your father died in 2005.
Yes. And I applied in the 2006, within 1 year.
Okay.
And that was scrutinized in the year 2010. And government approved my post and directed the director to give him appointment. And the director issued letter to DO Kendrapada. But Kendrapada stated that there is no vacancy. So the director again issued letter to the DO of Jagatsinghpur. But they are not taking any action. My case has been scrutinized, approved by government, but they are not taking.
So in your case, no decision had been taken. It was pending.
No decision has been taken, and for which And the rest part of the case is covered to my.
Rest part we are not applicable. It says peculiar facts and circumstances of the case.
Yes, my.
So we'll hear you. The delay is only how many days?
136.
Sorry.
32 days.
132 days. We are condoning the delay. Then we'll hear you on merit. We are not allowing the case on merit.
So we have the lordship has had the matter and 20 years have already passed. My in the meanwhile.
Orders for condonation of
Yes,
delay.
I know that.
Yes.
In the meanwhile, 20 years have already been passed, but they are not taking, not giving up. Government has approved a post.
No, exactly.
We'll decide.
You are saying you have applied since 2006, but you came up to this court in after 14 years. You filed the writ application after 14 years. So you bring the decisions also where the Supreme Court says that after lapse of so many years, the question of
Counsel, we are condoning the delay. We will hear you. If you want that this matter should be expedited, we will expedite hearing. All right. Don't dictate us.
No, I have
Yes, the matter has come for.
Come the decisions. Then we'll hear you on the next day. All right. IA 2678 of 2023. This IA has been filed for condonation of delay of 132 days in filing this writ appeal. Mr. SP Sahul and counsel appearing on behalf of the respondent submits that his case is squarely covered by the case of Malayananda Sethi, for which the matter should be heard on merit. Full stop. Considering the grounds taken in the IA and in the interest of justice, we are inclined to condone the delay in filing the appeal. The IA is accordingly allowed. The delay is condoned. Delay in filing the appeal is condoned. The IA is accordingly allowed and disposed of. This is the case on 26.
No, my lord, in the month of December, my nephew's marriage is in the October.
So you gave a date. You wanted urgency, so I was listing it next week.
Next week, 10th of December.
All right. This is the case on 10/12/2024 for fresh admission. In the meanwhile,
What is that? Apno ko iksha.
have you received a copy of the appeal memo?
No.
Mr. Bibisar Das, learned additional government advocate, undertakes to serve a copy of the appeal memo on Mr. SP Sahu, the counsel for the respondent. The copy of the appeal memo is served on Mr. SP Sahu and the counsel for the respondent in court.
Item 19.
Pardon, just pardon. Item number 16.
Yes.
There was urgency. State has taken for instruction. There, the last date of filing the documents for processing the extension of approval, which is statutory, is fixed to 18. It was 18. The last date is 20th.
18th of?
18. Now, last date
18th is gone. 18th is gone.
November.
Yes.
So,
18th November is
last
gone.
date is 20th.
You're saying fixed to 18th?
20th.
Yes.
Last date. And the semester examinations are going to start from also from 20th itself.
Why have you come today?
So I have filed, that's why I mentioned it, the matter is there in the list. So that's why I wanted that let it be taken out.
But without instruction, how can we do it?
Why? Because that extension approval is statutory. The institution has to file it online because they're not allowing us to enter.
No, but why are you waiting till the nth moment? That's
No,
what I'm
we have
saying.
come. We have come earlier. We have
So
filed last week.
when was it listed?
Listed first time today. It was mentioned on Friday.
Exactly.
When did you file?
It was filed on 4th.
Mentioned yesterday.
4th. It was mentioned there.
You filed it on 4th.
4th.
When did you mention?
I mentioned it on, I think I said Thursday I mentioned it.
Thursday you mentioned.
Because why?
And your matter has been taken up today
Yes.
on your mentioning.
Yes, madam.
And you have still a grievance.
No, what has happened in the meantime, this AICT and BQT, they have come
Just a minute, let us see.
that have come up with the examination schedule after filing.
After filing, you
Yes.
filed.
We have filed the IA. Now the BQT has
So
come.
when did you file your writ petition?
Read petition filed in 2015. The IA has been.
Why the petition was disposed of?
No, it's pending.
It's pending.
Yes, the order has been passed. In spite of the order, they're not implementing it.
No. What is this IA about?
This cannot be heard.
No, we will not hear. What is this IA about?
IA is regarding that for filing, they should allow us to enter the institution and make the process of approval.
Enter the institution means?
They're not allowing us to enter the institution. Principal. They're not allowing the principal.
This is your insight. Will not do. You manage.
No, that's the order.
Sorry.
Lordship will see the order.
Sorry.
Yes, that Lordship is the one order. High Court has passed an order.
Sorry.
Confirmed by Supreme Court.
Sorry.
That order is then what is your worry?
No, we have also reported this matter to the collector and the SP. They're also, we have brought to their
All right. They'll do.
Only question is that.
No.
Can it be that?
Sorry, prima facie I am of the view that this application is frivolous. The application which you have filed, this interrogatory application which you have filed, is frivolous.
We have filed because they are not allowing us to operate.
Who is not allowing?
The staff.
Very good. You are principal and your staff is not allowing?
Yes, let me see that.
Wonderful.
Because
You are the principal
Please,
secretary.
we will not pass any order.
Can I just make a submission? The society is running it and the principal was in charge. They're not allowing the principal to function. The staff, they're holding on strike and all.
IA number 1. Yes.
Can I press?
No.
Let them take
No.
We
Dismiss.
have asked them to take
You
instructions.
Let them take it. Let them take it.
No.
Let them take it.
No instruction. We will not enter into such dispute.
Item 19.
Can I pray?
Sorry.
Let them take it.
Sorry. No.
At least otherwise they
No, not at all. Not at all. These are private disputes. We shall not enter into this.
The order has been passed by the High Court.
All right.
Can I just let them take instruction?
Sorry, sir. Sorry.
Let them take instruction and we'll cooperate.
19.
There's an order passed.
Okay, we'd ask them to take instructions.
Okay.
Yes, okay.
19.
Minus, there is a delay of 40 days.
Condoned.
Delay of
40 days.
which one?
19.
40 days, yes. But what is the merit in your writ application? Unauthorized absence, you were not paid salary from January 2006 to June 2006. So the learned single judge has passed the reason.
They have passed the order. But if by not
After an inquiry. All right. IA, no private respondents.
no.
The college must be there.
So one principal is there.
No, other side is appearing. Who is for the other side?
19.
19. Who is appearing?
For state, I will tell.
No, for state you are there.
But opposite part number 3, respondent number 3,
Yes.
3. Who is 3?
Principal of the college.
retired principal in charge.
Oh, which college?
LG college. LG college.
Someone is appearing for the college.
First step. Issue notice on the question of condemnation of delay by registered post on the speed post will be within 4 weeks. And issue notice to the respondent number 3 by registered post along with oblique speed post written within 4 weeks, requisites for which shall be filed by 22/11/2024. Notice on behalf of respondent 1 and 2 is accepted by Mr. Bimbisar Das, learned additional government advocate. List the case up to 6 weeks.
7 January.
7th January.
Yes.
Okay.
Item 20.
Pointed out the delay of 500 some days, but earlier I have filed a writ appeal challenging the order passed by the Honorable Single Judge and delay has been condoned in that writ appeal matter. Petitioner has writ application was disposed of on 15/12/2022 and subsequently the order was modified on 20th January 2023 by the Honorable Single Judge. I have filed a writ 892 by 2023 on 1st May 2023. Subsequently, this Honorable Court has been pleased to condone the delay on 6th December 2023. Thereafter, at the time of hearing, this Honorable Court disposed of the writ appeal, directing to file a better writ appeal, including all the documents for which this writ appeal was filed.
After 7 months.
7 months.
Took you 7 months to get the documents. And in that earlier writ appeal, this court had granted you time on 4 occasions to remove the defects. So, is there any, anything there in the writ appeal or just for the sake of filing you have filed?
Your Lordship, kindly see, the ad hoc promotion was granted.
Yes.
And there is a condition that he will not claim seniority.
Yes.
That is the 89 days promotion. And he has accepted that condition. And after that period has gone, 89 days, he has been devoted. Twice it has been extended, subsequently he has been devoted to the previous post because his date of retirement in the next month. That he has challenged the order of reversion as well as pay protection. This Honorable Court allowed, the reversion has not been stopped, but this Honorable Court directed to grant the higher scale of pay. That is under challenge. Because once ad hoc promotion has been granted,
Union government.
No, you.
only private respondent.
So what should we do?
My Lord, first of all, my Lord, I have challenged the condemnation of delay. My Lord, I have filed an objection also. I have cited 6 judgment also. The government continuously.
No, in earlier writ appeal was filed.
Yes, my Lord.
And there was delay.
Delay.
The delay was condoned.
Yes, my Lord.
And thereafter, he was permitted to withdraw the writ appeal.
I did it. She is with the
Yes, he was permitted to withdraw the writ appeal with the liberty to file better writ appeal. Now he has filed better writ appeal.
After 7 months, my Lord.
After 7 months.
Yes, my Lord.
We can impose cost. 10,000. Because delay is of 210 days.
Near about 200. Earlier writ appeal, my Lord.
65 days.
Delay.
That was condoned.
Yes.
This court has granted him liberty to file. Because he took us such a long time, we'll award cost. All right.
Phone number 1. Now it's 75 years old.
So we'll hear it
Yes, ma'am.
shorted. IA 628 of 2029. What about the certified copy?
Certified copy, my Lord, I have already filed certified copy in the earlier writ appeal.
So,
For which time I'll file.
all right. This writ appeal is there. IA 6282 of 2024. This IA has been filed for dispensing with filing of certified copy of the impugned order. Which paragraph have you stated that it has been filed in the other writ appeal?
Paragraph number 4. The applicant is on the earlier writ appeal number, which is this one, certified copy, but is already filed in the.
Yes, Mr. B.R. Bhokal and Central Government Council submits that the certified copy of the impugned order was filed in WA number 892 of 2023, which was disposed of on 31/2024, granting him liberty to file a fresh writ appeal with better particulars. Something the said submission, the writ appeal has been tagged along WA 892 of 2023 has been tagged with this writ appeal. Considering the said submission, the prayer for dispensing with filing of certified copy is allowed. IA is disposed of. Then IA number 6281 of 2024. This IA has been filed for condonation of delay. The stamp reporter has indicated a delay of 588 days in filing the writ appeal. Produced the additional affidavit filed on behalf of the appellant. Filed on behalf of the appellant, it appears that writ appeal number 892 of 2023 had been filed challenging the impugned order, and the delay of 65 days in filing the writ appeal had been condoned by this court. Thereafter, the writ appeal has been disposed of on 31/2024. Granting liberty has been permitted to be withdrawn on 31/2024. Granting liberty to the appellant to file a fresh writ appeal with better particulars. Full stop. Thereafter, this writ appeal has been filed on 23/8/2024. So, in effect, there is a delay of about 200 days, 210 days in filing the writ appeal. Full stop. Mr. Sapan Kumar Pal, learned counsel appearing on behalf of the respondent, submits that the respondent aged about
75 years.
75 years and is waiting for the what was the order?
Enhanced scale of pay.
And is waiting for implementation of the orders regarding sorry.
In this judgment, my lord, the cover judgment.
All right. Enhanced scale of for payment of enhanced scale of pay. Considering the averment of the IA as well as the additional affidavit, and after hearing the learned counsel, we are satisfied that case for condemnation of delay is made out. Condemnation of delay is made out. We are therefore inclined to condone the delay in filing the writ appeal, but subject to payment of cost of ₹10,000 to the respondent within a period of do it 2 weeks because already delayed. Within a period of 2 weeks. You received a copy of the appeal memo?
No, I am not.
The IA is accordingly allowed and disposed of. Full stop. Writ appeal Lekantu. List this case on 3rd December 2024 for fresh admission. Full stop. Mr. D.R. Bhoktal and Central Government Council undertakes to serve a copy of the appeal memo on Mr. Sapan Kumar Pal by tomorrow.
Mr. So how much court fee do you pay for filing an application? Like for exemption of certified cost? How much court fee?
₹6. And so far the affidavit person is concerned, ₹3 plus neutrality.
And how much do you pay to the typist? Each page? Must be ₹10. And then notary? And then drafting? And why can't you file the certified copy? Instead of filing in an application for exemption from filing certified copy?
This has been tagged, my lord.
Even if that was tagged, if that is the requirement, and without paying even a single pie, you can get a certified copy. Why don't you do that? Instead of filing this application, then getting an order and everything. Why?
One.
21 we are and for the OP number 4.
At the same time, we used to do counter affidavit. And just one.
The state government has filed a counter, but opposite party number 4 has not filed any.
Just one moment. In that item 16, just add one line. The registry is directed to bookmark the applications file. Bookmark the applications file. After 2023, the bookmarking has not been done of the IAS. Okay, item 16. Please give us list of file goals. All right. Sorry. Item 21. Yes. Because your IA says that the counter affidavit is there, but there is no counter affidavit on record.
Yes,
Where is the counter affidavit? File card le?
Have you served copy?
We have received. We have received counter, we have filed a rejoinder also.
The regional copy they have not submitted.
This item 21.
Is that
21, yes.
regional here? It is a drinking of the project.
Just one moment, we don't have anything with us. Rejoinder, when did you file?
23/8/2024.
23/8.
2000.
Take it up after this.
Physical copy there is, counter is there.
Then why have they not scanned and bookmarked? We'll take it up after recess.
We'll take up after this.
We'll take it up after recess. You are there? Tomorrow.
Can it be? Your Lordship may fix the hearing because what he says is, we have challenged the award of the tender. Now he says that allow me to execute the tender. It actually entails hearing of the application.
So we'll hear it.
So that's why I say your Lordship may fix it to any date next week. It can be done.
My humble submission, he challenging my technical bit, the stage where already LOI issued Miller. And we are deposited by performance security. He is nothing deposited. I deposited entire performance security.
So we'll decide your IA and keep the writ application pending.
Yes, so my saying that there is no rate
that is
pending Miller. It will not embargo to execute agreement Miller. Any subject to
We
because
can
this is a
grant
printing of a project.
We can grant interim order today if you want.
Miller, it's
In case lack of interim order is causing inconvenience to you, we can pass the interim order. We'll take it up tomorrow. All right.
The date is of a rejoinder copy. But
Can it be next? Can it be next Monday, Tuesday, your Lordship?
Thinking of a wedding,
one copy of the rejoinder copy.
Yes.
IA 13439 of 2024. Learned Mr. Devashish Tripathi, learned additional government advocate, submits that counter affidavit has been filed in this case on
22/7/2024.
22/7/2024. Full stop. Learned Mr. Gautam Mukherjee, learned senior counsel, submits that the rejoinder affidavit has been filed on
23/8.
23/8/2024. It appears that these two documents are available on the record, but unfortunately they have not been scanned or bookmarked. Smart, I didn't find it. There.
Yes.
Fine. Well, anyway, we'll
Page, digital page 264.
all right.
Physical page 245.
But unfortunately, these documents have not been page marked. Full stop. List the case for list the case. List the case on 26/11/2024 within the first 10 cases, so that the application can be disposed of on the same date. Yes.
The rejoinder copy can be right. Sorry.
I will have it.
Parties to exchange their pleadings if not already done in the meanwhile. If not already done by 22/11/2024.
Okay.
Exchange the pleadings by 22/11/2025 if not already done. Yes.
Punishment over.
Yesterday?
39.
Is there. Item 39.
I please. This is the matter related to admission to PG course was a hard one. Just to recapitulate loss in memory, let's kindly come to page 19. This is the policy. Page 19. Annexure 2.
This relates to admission to PG.
Yes, postgraduate medical for PG.
Referring to which next year?
annexure 2 at page 19.
Yes.
You also see that your letter, postgraduate medical, post MBBS, MBS, diploma course in government and private medical college of the state, 24-25. 24-25. And the bottom will also see approved by the government of Orissa. Is it correct?
Yes.
Approved by the government of Orissa, then approved by WAS 5 numbers also dated 2/3/2023. Then you also kindly come to page 24 of that policy guideline. Eligibility.
Page 24.
Yes.
Yes.
To be eligible, a candidate must have passed MBBS from NCI recognized institution equivalent and must have following criteria. We are concerned with two. Must have qualified in NEET PG of current year. Okay. NEET PG of current year, securing the qualified mark are prescribed by the MCI or NMC. Then you also kindly come to G2, in-service candidate. An in-service candidate is one who at the time of application is under employment in Government of Orissa, Government of Orissa Public Sector Undertaking, Government of India Public Sector Undertaking, located in Orissa, Defence Service Orissa, and has completed a length of 3 years of service, including all categories of employment like contractual, temporary, ad hoc, regular, by 31st March of the current year of admission. The current year of admission. Then also come to the page 25. Page to next page, page 25.
Yes.
You also look to NB. NB. The cut-off date 31st March mentioned above is subject.
You are reading 25?
Page 25.
Yes.
NB. NB. Just top. 3. Just below.
1B.
Yeah, yes, below
NB.
fourth line.
Achha. Oh, NB.
Yes, sir. NB. NB. N for New Delhi.
Yes.
The cut-off date of 31st March mentioned above is subject to change as per any change in the schedule of NEET PG. Look at it. Change in schedule of NEET PG or All India Council, which will be notified. Sir, kindly come to page 29 there. And this, also come to page 29, Annexure 3. This is National Board of Examination in Medical Science. This was notified on 9th January 2024. Also look to the top right hand column. 9th January 2024. That is why they are fixed it to 31st March. And if you also look the first paragraph in supersession of so-and-so, pursuant to notice that so-and-so, the conduct of NEET PG 2024 examinations, which was earlier notified to be tentatively held on 3rd March 2024, stand rescheduled. The NEET PG 2024 shall now be conducted on 7th July 2024. Then you also kindly come to page 30. Subsequently, page 30 will. On 16th of 2024, also see the top. Application invited for national eligibility come entrance test. If you also will come to page paragraph 2, National Board of Examination in Medical Sciences shall conduct the NEET PG 24 on 23rd June 2024 on computer-based platform. This is they fixed it to 23rd June. Then you also kindly come to page 31.
23rd June, on 29th, it has already been fixed to 7 July. They have pre-port.
You also look to the pre-port. That is at page 30, that was pre-port. Application invited for national eligibility.
Yes, pre-port. Then final date is what?
No. Then you also kindly see page 31. On 22/6/2024.
Not notified.
Not notified, 24.
Yeah.
The NEET PG 24 schedule for 23/6/2024 has been postponed. Then 2. Test date for NEET PG 2024 will be notified at the earliest. They said that's then sir kindly come to page 32. Page 32. On 5/7/2024, the NEET PG 24 shall now be conducted on 11th August 2024 inclusive. The cut-off date for the purpose of eligibility to appear in the NEET PG shall continue to be 15th August 2024. Our examination has been conducted on 15th August. We appear, we qualify on 15th August. Now,
No, you must have appeared on 11th August.
sorry, 11th August. That is second paragraph. NEET PG 2024 shall now be conducted on 11th August. That we have appeared in that. Now, why we approach your worship? That is at
So when do you become eligible? By which date?
by the date when the
So which date?
that is on August, 11th August or 11th August.
As of March 31st, you were not eligible.
Right. By June, that is what you also rightly said. And by June we will be eligible. That's another problem. So if you look to page, when we have approached your worship at Annexure 6, and Annexure 6, they fixed it to the registration was fixed to 1/11/2024 to 5/11/2022. The matter was listed before worship on 5/11/2024. The worship after hearing passed this order. Yes, sir. That is at other decade.
You mentioned that you have registered for the other open candidate.
Yes, I have also mentioned that without prejudice to rights,
Yes.
we have also registered that. But in service candidate, they are not in a position. That is why you should notice, and your worship directed them to file counter an affidavit.
The earlier writ application, another year.
That's it. Well, I am sure coming to that. Now, a counter affidavit has been filed by the counter. Say, look to the counter. Before your worship look to the counter, can I give your worship a short date of events, which may be necessary because I am taking your worship to the counter. They rely upon two judgments. One judgment of this court, the other judgment of the Honorable Apex Court. Your worship, just I am giving the, so for that case, you can look at the background. Your worship.
I said this court is not honorable. Honorable Apex Court, this court and Honorable Apex Court.
Oh, sorry. That's
No.
sorry.
On a lighter note.
I'm extremely sorry.
Yes. Yes, madam. Yes.
15/10/2020, the state government, the Department of Age and Family Welfare approved the guideline for counseling and admission candidates for PG medical and PG post MBS diploma course.
So that you have already placed.
That's right.
So you don't have to repeat it.
In 2020, I'm showing there is something in the said guideline. The NB to clause G was absent, was not there in 2020. In 2022-23, serial number 2, NB to clause G of the guideline for counseling and admission of candidates for PG medical and post MBBS diploma course in government and private medical college state was incorporated for the first time in 2022-23 without the approval of the government. You also kindly mark it. From 2022-23 without the approval of the government. Then on 18/6/2022, a corrigendum was issued by the DMET Orissa, changing the cutoff date from 31/3/2022 to 31/5/2022. Initially, it was not approved. Then they issued a corrigendum after the process was begun. Corrigendum. Then 30/8/2022, the corrigendum dated 18/6/2022 was challenged in WPC number 16772 of 2022. The said writ application was disposed of by quashing the corrigendum dated 18/6/2022, and it was held that the corrigendum for postgraduate guideline to be prospective in nature. I will show that judgment because they have included that judgment. That was on 30/8/2022. Then 2/3/2000, and the judgment also, the other paragraph finding is that it was not approved by the government, therefore it is not permissible under law. That I'll show you also. Then on 2/3/2023, the NB to clause G was incorporated in the guideline for counseling and admission of candidate for PG and post MBBS diploma course in government and private medical of the state 2024-25 with the approval of the government. I was showing you this has been approved by the government. Then on 9/11/2023, NEET PG 24 was made. I've just placed it, your lordship, need not place it. Then this was the schedule of NEET PG was rescheduled time and again. Ultimately, it was held on 11/8/2024. That is that date set from serial number 6 to 10. I've already placed, I need not place. Now you also kindly come to the counter affidavit. Counter affidavit filed by on behalf of the OP number 224. If you also will look to
Let us see the this clause again.
yes,
G.
You also come to page 24
25.
and 25.
Let me see 25 first.
Yes. The cut-off date, may I read it again? The cut-off date of 31st March mentioned above, mentioned in G2, in-service candidates, mentioned above is subject to change as per any change in the schedule of NEET PG and or India Council which will be notified.
Which will be notified, so it is not automatic.
No, they have to extend it. They have to make a notification for extending it.
Have to.
Because if in view of the NP, if I have correctly understood,
May.
They may. Then yes, the May, what is not there, the cut-off date 31st March mentioned above is subject to change as per any change in schedule of NEET PG. Am I clear? Now you also look to what is their study. Your lordship, I remember your lordship asked in the your lordship passed an order on the earlier occasion. Your lordship asked that what is your stance so far as this NB is concerned? Why not just Chief Justice, only Chief Justice asked that question. Now you also see the counter. Counter, if I have correctly understood, I have read the counter, they have taken two grounds. One, two judgment, because the corrigendum they have earlier issued in 2022 that has been crossed by this honorable court, so they are bound by this judgment. That is one. And another judgment they have enclosed, under Supreme Court's judgment, they say that that judgment, in view of that judgment, you can't question it. But those judgments, you also just I'm taking to lordship to those judgment. If you also will say that this judgment is directly applicable, that the position is different. But if I just take your lordship to those two judgments.
But the one thing, that judgment in WPC 19169 of 2000. 16772 of 2022.
I have given you.
What is the meaning of prospective in nature? So that is for that particular year.
So far the corrigendum, I'm showing you. I'm showing you. So kindly come to the judgment, the division by judgment incidental. I was also counsel. The judgment of this honorable court, page 13, annexure A by 2 to the counter filed by the OP number 2124.
Yes.
The petitioner, first line, just what is the subject matter? The petitioner who are in service medical officer of filed with application to quash the corrigendum notice for the PG guideline 2022-23 dated so issued by the OP number 3 Director of Medical Education and Training, Odisha under Annexure 7. You also kindly come to page 19, running page 19. Para 3.3.
Yes.
Yes. It is further contended that before making any change to the guideline, DMET has to take approval of the OP number 1. But the same having not been done on 15/10/2020, that is much prior to issuance of the corrigendum, such approval cannot have any application in respect of the corrigendum, which is the subject matter of challenge the writ application. This is one. This is of course that contents which are noted. Then they also kindly come to the operative portion of the judgment. At page, let's come to page 36. Page 36, yes. I'm reading from the middle portion. Therefore, I'm reading. Therefore, any requirement.
I'm sorry for interrupting, just one. The previous paragraph says the examination had been conducted after which the corrigendum was issued.
Yes.
So in that case, corrigendum has been issued after the examination.
Yes. After the NEET examination was conducted, it was issued, a corrigendum was issued. Of course, that corrigendum also without approval of the government.
Yes, that you
That's right. That's
mentioned.
then kindly come to page 36.
Page 36.
Yes, sir. Yes.
Page 36.
Yes. I'm arguing the first item, I don't feel that. In the second item, I let me. 36. Therefore, just reading about 8 lines from the top. Therefore, any requirement oblique selection has to be made on the basis of the process, oblique policy, oblique law existing on the said date. Therefore, the guidelines oblique policy would operate only prospectively. That is from 27/5/2013 for future examinations that may be conducted. But insofar as the admission of PG medical course for in-service candidate is concerned, for the year 2013, clause 8(2) of the interim guideline cannot be made to apply to such admission. The seat reserved in-service candidate for the year so and so. Let's skip over there, refer to another case. Then let's kindly straightway come to various judgments have been referred to para 31 at page 42. Page 42, para 31 is the operative portion of the judgment. Applying the second principle of law, as discussed above, to the factual matrix of the case at hand, this court is of the considered view that the corrigendum notice for PG guideline 2022-23 issued on 18/6/2022 in Annexure 7, fixing the cutoff date for in-service category, that the completion of 1 year of compulsory rotating internship and housemanship, as mentioned in the guideline for the postgraduate medical and post-MBBS and MBEMS diploma for the academic session 2022-23 shall be read as 31/5/2022. That is the corrigendum. Instead of 31/3/2022, cannot sustain in the eye of law. And the same is liable to be quashed and hereby quashed. Thus, it is directed that, adhering to the postgraduate medical selection Orissa guidelines issued for counseling and admission of candidates for postgraduate medical and post-MBBS, MBEMS diploma courses in government and private medical college of the state, 2022-23 in Annexure 3, the selection has to be concluded. Needless to observe, the interim corrigendum for PG guidelines 2022-23 may be prospective effect and cannot have retrospective effect. Same MB which was issued, of course, that was not approved by the government. Here it has been approved by the government. And that is the policy. That is the policy of the government. Then the other judgment which they have referred to, if your lordship will look to at page 159, Annexure C/2, the judgment of the Apex Court. Shikhar and Dhanadhar versus National Board of Examination. First paragraph, you also look what was the subject matter in that special petition, writ petition. The petition under Article 32 of the Constitution has been instituted by doctors who are aspirant of NEET PG 2022. They have challenged the deadline set for the completion of internship for appearing for NEET PG course PG 2022. The fact which is right to the present petition. So for the present cases, we have already qualified in the NEET. There they wanted to postpone the NEET examination. On the ground, because of the COVID and other things, they could not be able to attend. You also come to that paragraph 15 at page 167. Bottom. I'm reading the bottom. The factual matrix at page 167, internal page 9 of that judgment. Does it get it?
Internal page 9, yes.
Yes. Para 15, I'm taking the lordship to the bottom first. I'm reading the whole line. The petitioner have sought to rely on an order of this court in so-and-so case where the Institute of National Importance combined admission test INC-CET for admission to the postgraduate courses for the year 2021, July 2021 session was directed to be postponed by that year. The consideration was weighed with the court. Inter alia was that owing to lockdown in several states, it would have been virtually impossible for the candidate to reach the examination center. Further, it was observed that many of the doctors who would be appearing for the examination were exposed to COVID-19 and would have to quarantine and isolate themselves. There is also an apprehension that conducting the examination at that time would lead to spread of the virus. The relevant observation reproduction did not place it. Let's come to the bottom portion. The factual matrix that led to the postponement of INA seat was completely different from the present circumstances. Crucially, the case dealt with conducting of an examination during a pandemic where strict lockdowns were placed. It did not relate to fixing of a cutoff date, which is bound to exclude some aspirant and include others. The law is clear that such exclusion will always be incidental to fixing a cutoff date and cannot be turned arbitrary. Thus, on considered view of the matter, it would not be appropriate to entertain the petition on Article 32. So there they wanted to postpone that examination because of various grounds. That was not 32 application was rejected. And these two decisions they have relied upon in their counter. If you also look to the counter at page 7, paragraph 11 to 13, that said that because of the judgment of the division bench of this honorable court in the year 2022, page 7. Page 7, they have quoted that and they say, just above paragraph 11, so the cutoff date for completion of internship is fixed to 31 May 2022, which was 31st March of every year. That in consideration the aforesaid information bulletin and the point number 3 under clause G of the guideline of the state government, the corrigendum was issued by revising the cutoff date of 1 year internship to 31 May 2022 from 31 March 2022, which was the subject matter of challenge in the aforesaid writ petition hearing number 16772 of 2022 in the matter of Dr. Banisha Swanso versus State of Orissa. 12. That after hearing at length, the aforesaid writ petition was disposed of by this honorable court on 30/8/2022. And in the same judgment, it is argued that the conditions stipulated in the guidelines so published have a binding effect on all candidates, and so far as the cutoff date for in-service candidate is concerned, the same has been prescribed under subclause 2 of clause G. Adhering to the same, if the petitioner and similar situated candidate have participated in the process of selection, appearing in the examination on the scheduled day, and result was published, subsequently they have to change the argument is also advanced that parties are not permitted to change their stand when the process of selection has already been started. Thereby, promise which has been held out pursuant to the guideline fixing the eligibility date 31st March of the current year, that cannot and should have modified
in addition to the persons, officers impleaded as opposite parties in the present suo motu proceeding, comma, let following be also impleaded as opposite parties, as the Union of India to its secretary, comma, secretary, Department of
Ministry.
Environment and Climatic Change. That is the department.
Yes, yes.
Is it department or ministry?
It is Ministry.
Ministry of Climate.
Secretary, Ministry of. And the director of wildlife preservation as preservation appointed under Section 3 of the Wildlife Bracketed Protection Act 1972. Full stop. Mr. Who is appearing for the? You will appear, Mr.
I am appearing.
Huh?
So for the Union of India is concerned, I am appearing.
Das so accepts notice on behalf of
Dear Bhokta.
Union of India. Yes.
In fact, just to assist your lordship, this suo motu, it can be taken up, but this issue is already there. My lord would recollect and
Those cases have been listed.
They're all there.
Hello.
Three cases.
Really, there's a JTF form, and they are in session of all these. So those two orders, your lordship will see. Similar occurrences have occurred, and the court has expressed concern regarding these deaths. So your lordship can merge.
In fact, we had asked for that meeting to be held, which ultimately could not be held.
No, it was held.
We are not there. Okay.
The presentation happened. So now they just have to, everything is in place. They have to be just brought back maybe on virtual mode so that it can be. Your lordship could see just two orders, whatever I could get.
After that, probably, I don't know, it was not listed. Not been listed.
Not being listed.
Even they have filed an action plan.
Yes. Last order, I remember, we'd asked for a joint meeting to be held.
So if your lordship would see that order of 2022, which is in that
22 or 23?
recycle paper.
22 or 23?
22, similar occurrence had happened. That recycle paper, I'm sorry, I could.
No, that's fine. You had given us 20.
Order number 10, dated 13/12/2022. Similar deaths had occurred, and the court took note, preponed the matter, and then
Action plan also submitted, my lord, by Conservative Wildlife. And there is a demonstration how action has been taken, what is the plan in this, on a conference hall in presence of.
Yes, that we had ordered.
That
Thereafter,
is there, I have passed on
matter
that
was
part.
not there.
Then after this matter is not listed.
List this matter on Monday, along with WPC number 14706 of 2022, 195 of 15, WPC number 9056 of 2013.
Double to 421 or 15 also,
Just-
another
just-
matter.
No, but there's so many.
That's elephants. Other different, right, other reasons also they want to.
No, whether it was noticed in proceeding that about the deaths of so many.
This is a recurrent problem.
Last year.
So one such order I showed where there was a death and the court preponed and
One death of one in fact.
thereafter in the meanwhile during this pendency many such occurrences have occurred. This is another such instance where when the court is monitoring this, again the situation has got out of hand and people, the elephants have died. There's a JTF
This was of
constituted
last year.
JTF constituted
by this court to monitor this.
where is that JTF?
Now, the Lordship would see the order dated 29/8/2023, order number 18. Copy of that. Paragraph
Gautam Mishra and senior counsel assisting this court has drawn our attention to this court's order dated 13/12/2022.
And 29?
and 29/8/2023.
13/12/2022 and 29/8/2023.
29 is order.
We have given a photo.
2023. It's not complete.
29 okay.
It's complete.
29 is there?
Ah.
All right, it's there, it's there.
29/8, your Lordship may see paragraph 7. Mr. Manoj Nair, he heads this JTF. He used to appear online, if your Lordship may recollect. He was the person making these. So if he is brought on board now, things can be quickly redressed. Para 7 of that order. He was the PCCF wildlife.
Correct. 23 passed in the aforesaid batch of writ applications. Stop. The order dated 13/12/2022 reads as under. Stop.
Yep.
Paragraph 7.
23.
23.
Para 7 of order dated 29/8/20.
Order dated 29.
29/8/20, that is order number 18.
Want this.
Okay, okay. I thought you were looking at this way.
Yeah. The order dated 29/8/2023 reads thus, as paragraph 7 of so reads only paragraph 7.
Para 7 shows the name of the person. He is the person heading the JTL constituted by this court.
List this matter on Monday, on which Monday to be taken up at 10:30, to be taken up at 2.
Monday, I have an outstation. I can't be on the outstation matter on Monday. Can it be on Tuesday?
Tuesday. Stop. In the meanwhile, Tuesday when what is his name?
Mr. Manoj Nair.
When Mr. Manoj V. Nair,
Dr. Manoj V. Nair.
Dr. Manoj V. Nair,
He's still there? He's still there?
is he still there?
Already.
He is no longer there. So the present
I'll ascertain who is there.
We ascertained, you said he's still there, is he there?
When Principal Conservator of Forests, bracketed wildlife, shall be required to be present, required to join the proceedings online. Stop. He will further be required to furnish to this court the number of deaths of the elephants in the state of Odisha reported discussion from 2020 till date, displaying the known reasons for their deaths, comma, by way of an affidavit. Full stop. He shall also disclose in the affidavit the steps taken to investigate the cause behind the deaths of 3 elephants, as reported in today's newspapers.
That,
That'll do.
that will be because they are there, the body is very much, they have a body of police officers also in that jail.
Is there?
Supplemental list item number 1.
Yes. Constitutional lordship last direction for the state to take instruction. The constitutional lordship last direction to take instruction. They have carried an affidavit from life, which is not on the lordship report. I got a copy, but since that affidavit is not on the lordship record, lordship may take it day after tomorrow.
So someone,
They gave me a copy.
have you seen?
They gave me a copy.
He filed it yesterday.
Yesterday they have filed. I got a copy.
Stated by the
Yeah.
senior counsel appearing on behalf of the petitioner that an additional affidavit.
They have filed reply to that instructions your lordship directed
Yes,
for status of my rights vis-a-vis that hotel.
What is the affidavit styled as?
Affidavit is,
Additional affidavit.
they call it affidavit on behalf of collector. of
The additional affidavit dated?
Yesterday.
Yesterday, 18th.
18.
Filed yesterday, but
Filed yesterday.
so of yesterday also.
Yes, sir. Filed yesterday. But I have not filed any affidavit. This is the only affidavit. Filed yesterday, sir. I have the lordship got that copy.
And that
I have the lordship got that copy. No, I am.
copy of the affidavit filed on behalf of the collector has been served today itself. Stop. He seeks adjournment to consider this affidavit.
I've seen it, but I don't want to argue today with
All
this.
right.
Because
Day
we
after
don't have it.
tomorrow.
All right. As
Day after tomorrow.
or is still is this matter on Wednesday, retaining its position.
Wednesday is tomorrow.
Wednesday or Thursday,
Thursday, sir.
retaining its position.
Item number 2.
Similar related data field also has already passed on order. In the last date, also had expected to take instruction of the same. So the order that will be passed in the
Because he said it is covered by that decision, we had asked you to check.
Go with that.
Yes, sir.
Item number 3.
In this matter, you have to Parity will take instruction whether the prosecutor is going to return that money deposited by the Fiscal or not, and for keep the instruction as process and strategy. Then mapping money to affidavit to Parity.
It was on 1811. What has happened thereafter?
After, now that processing the file for the collector is important.
Then do it.
Refund. That's it.
How much time will it take?
2 weeks.
2 weeks. Seek instructions because we will keep the matter for that day. And if by that time the amount is not paid, then money is not refunded, then we will impose cost.
By the way,
So seek instructions. Tell us. Who is for the petitioner?
My
They are ready to refund your amount.
last year in my file counter not again.
What counter?
Item note 3.
What counter? No counter. They were asked to obtain instructions.
Reply or file not filing till date.
Huh?
Not filed till date. The not dated file.
Learned counsel appearing on behalf of learned AGA appearing on behalf of the state of Orissa has produced before us a communication dated 18/11/2023 made by the Tahsildar Lanjigarh addressed to the collector Kalahandi seeking permission to refund the
Tripathi, we had asked you to file a counter affidavit stating whether you are inclined to return. This letter says High Court directed to return and file affidavit.
that is the misstatement. I will file an affidavit.
No, but what is the meaning of this letter? Can't understand orders passed by the High Court.
refund the amount deposited by the petitioner for grant of lease pursuant to notice dated 2/1/2023. So next, by an order at 5/11/2024, the state opposite parties were directed to file a counter affidavit as to whether they were inclined to refund the amount or not, else the court would direct the refund of the said amount, would consider issuing directions to refund the said amount with interest. So stop. No affidavit has been filed till date. First off, list this matter. This amounts to putting the petitioner to undue harassment. First off, list this matter 1 week within first 5 cases. The respondents are directed, the opposite parties are directed to file a counter affidavit in terms of the court's order dated 5/11/2024. Subject to payment of a cost of ₹1,000 to be deposited in the account of welfare and progress. Yes.
Item 4.
Order 29/10/2024 may can be seen.
Order dated?
Last order passed.
What is that?
That order was, government was directed to obtain instruction whether my appeal is finalized or not.
Yes. Yes.
Who's there for the government? Item 4.
Copy has not been received, that is right.
What copy? Oh, there's a defect pointed out that by the stamp reporter. You have not served copy?
That is the report.
There is no defect. And noting also there is no defect.
Please see the noting again. Please see the noting again.
Copy solved. Defect removed. The noting defect
Yes,
is.
stamp report is received. Objection. Not understand.
Removed.
No, the noting said stamp defect.
29.
The noting is
Defect pointed out by
pointed out as a removed.
removed. Okay, sorry, sir.
Office.
You're right. That is objection page, right?
Ask him to appear.
Removed when?
I mean, very initially it was removed.
No, because in case you have
After
not.
removal of the defect,
All
the
right.
case number is
Alright.
assigned.
Keep it.
The order of this court dated 29/10/2000.
I request my landlord to supply me another copy. Let it come tomorrow.
Is this matter on 1 week? First off, if in the meanwhile, this court's order dated 29/10/2024 is not complied with, comma, the sub-collector board shall be required to be physically present in court. For this court to consider initiation of contempt proceeding against him. Yes.
Item 5. It was okay.
I have sought copy Mr. for installation yesterday manner. And my lord is also, and Lord, I have got the instruction from DMIT office that I updated hours 6 November 2024. We are reaching to the JE, that is already there in my A64. A64. Right. While mentioning along with the memo, I have filed that document which my lawyer friend is getting my lord at only page 64 my lord. We are written to JE to look after this. We are written to JE about this NRA matter.
To come to this order dated 12/11/2024. Our order, it says the last date of admission to such course based on NEET 24 has already expired.
The last date for state counseling is on 25th of November to 29th of
special round of counseling is going to be started on 20th November to 25th November 2024, and the State Council has to be started from 25th November to 29th November.
So why has that been mentioned in the order?
That has been published in the website of the NEET, my lord. I have downloaded it and supplied to it last week on 12/11.
No. The dates which you have mentioned in the order, subsequently that has been extended.
Yes, ma'am. Yes. Actually, the
Correct, Mr. Mahanti. What you say? Extension of dates.
My lord, because the DMT office is dealing with this now. It is dealt by UJ. We are the one.
I have served coupling on Mr.
OJ has to give all the.
When did you serve?
Yesterday.
Then he usually comes. Is he no longer the counsel or what? Either he comes or an associate comes.
I will inform you. You also may take it after launch, ma'am.
In our order dated 12/11/2024. In the order dated 12/11/2024, it has been mentioned that last date of admission to MBBS course based on NEET 2024 has already expired. The counsel for the petitioner, however, submitted that the last date for admission has been extended to
November 25th to 29th, my lord. State counseling is there, my lord.
has been extended, and the last date has not crossed yet. Then we will have to issue notice. How can we pass orders in the absence of any? Again, I don't know what will happen in the meanwhile.
They've done any mixture of
Issue notice.
How will you serve? Take notice? 4 weeks? 6 weeks?
Speed. Special messenger, I will take. Special messenger, my lord.
You give the requisites by tomorrow.
Yes, ma'am.
1 week.
Special messenger can message you tomorrow. List on 26th.
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 Yes.
As the first case.
First case on 26th. Our first case achi submit kar diye. So you mark for this is first second. Another thing, if these complicated matters are listed on particular day, we bring to a notice. Today we will find first case. If you rock the happen directly, two case ka rahi
Submission item number 6.
Item 6, your lordship. First item, your lordship, Retrospective number 1834, your lordship pleased to condone the delay in the connected brief, that is 1831/2024. There is same delay, 54 days delay. For that reason, I pray that delay may be condoned and this appeal may be heard on merits. And all the respondents are appeared in this case.
Mr. Linka, in the connected appeal, you have.
Well, I have already filed objection to this one.
Yes.
Lordship, I kindly have a glance to my objection.
54 days delay.
Delay is not a matter.
Then?
The appellant has no locus standi to matter such an appeal.
That we can decide.
The person, the managing director is not the appellant. One person, Lakshmikant Kara, that is my sole objection. Who is not competent to file such an appeal?
The second one.
The same,
It is the same, but that had not been raised by Mr. Mishra, so we have
the
allowed.
objection they have filing this this objection also in 1834. The same objection has been raised by the respondent, your lordship. That the law officer is not competent enough to file the writ of appeal. The objection is before your lordship also.
Lordship, kind of last of the Voklatnama, the managing director has not signed the Voklatnama even. The law consultant who is not authorized person on behalf of the MD will sit.
It's too technical.
File an appeal.
Too technical. Don't go. Okay.
So therefore, at each instance, the delay may not be comparable.
See, have you stated that the corporation had not taken any decision to prefer writ appeal? Is this your stand? Is this your stand that the writ appeal has been filed contrary to the opinion of the corporation?
No, but
Why are you making, do you?
Something like that. There is no advertisement that he has been authorized.
Yes, who has authorized him?
Lordship, that document I will file before your lordship.
File it.
Yes, your lordship. This objection is vis-a-vis with the earlier objection in 1834. They have raised this objection also.
Then,
and your lordship is pleased to condone the delay of 54 days.
So because your lordship committed some blunder, therefore
not at
your
all.
lordship are bound to do.
No, not at all.
repeat that.
Lordship, I will provide that later where the
Why these
authorization has
objections
been-
should be raised at all?
Your lordship, I will.
You should be careful enough.
Yes, sir. I will file the document which authorize the law officer to raise the complaint.
Enter on. These cases on 1 week. See, for taking such objections, it should be done. Yes.
Item 7.
Seven.
May I please your lordship. The appellant in this case has challenged the interim judgment dated 21/5/2024 passed by the honored signatures in WBC number 15930/2010. The operative portion of the judgment, your lordship, is at
Annexure?
Annexure 10, your lordship, at page
65.
Annexure 9, your lordship, at page 89 is the operative.
Yes. Who are you?
I'm for the appellant, your lordship, the Indira Gandhi Institute of Technology.
Yes.
Thus, from a conspectus of analysis made herein before, this court holds that claim of parity raised by petitioners with their counterparts of UC Burla is justified. Consequently, the interim order passed by the Secretary under Annexure 4 is held to be unsustainable in the eye of law. Having held thus, this court would make it clear that petitioners would be entitled to pay scale of senior scale, that is senior teaching assistant, from the date of completion of 5 years service as teaching assistant. Such benefit shall be granted till the date they were promoted to a higher scale and or granted financial upgradation in the form of TBA/SCP/RSCP and MACP as the case may be. The financial benefits be calculated and revised and dispersed to the petitioners accordingly. Your lordship, the subject matter of this case is that in the year 1991, the present respondents joined in IJIT Sarang as junior teaching assistants. Then, in the year 1996, they made a representation to the principal IJIT Sarang that since they have completed 5 years of service, they should be taken over to the scale of senior teaching assistant.
This is not there in your date chart.
Lordship, I'll provide a date chart, not incorporated those steps.
Then what happened?
In 1996, they made a representation to principal of IJIT Sarang that since they have completed 5 years of service in as junior teaching assistant in IJT Sarang, they should be taken over to the scale of senior teaching assistant. And they relied upon a settlement made in the case of UC Burla to substantiate their claim. That settlement is at Annexure 2, Your Lordship, at page 25. May I place that? That settlement is dated 11/9/1981.
What was that settlement?
In that settlement, some of the junior instructors of UC Burla had made a proposal to the Board of Governors of Sambalpur University that they should be taken over to the scale of senior instructors.
So what is the relationship between UC Burla and this IGIT?
Your Lordship, in the year when this settlement had been made, UC Burla was a constituent college of Sambalpur University. At that time, IGIT was not in existence. IGIT came into existence in the year 1983, and it became a constituent college under the Utkal University. Both the Utkal University and Sambalpur University were aided by the government, Your Lordship. And in the year 1996, when the first representation was made, at that time also, UC Burla was under Sambalpur University and IJT Sarang was under Utkal University, Your Lordship. So both the colleges are under the government, but they are under different management, Your Lordship. One is under Sambalpur University, UC Burla is under Sambalpur University, while IJT Sarang is under Utkal University at the relevant point of time in the year 1996. Now, may I place that settlement, Your Lordship? What was held in that settlement of 1981? In that settlement, the junior instructors proposed to the board of Sambalpur University that they should be taken over to the scale of senior instructor, and their main ground was that the fourth pay commission aimed at reducing the number of scales of pay. So government, this proposal was referred to the government, and government decided that after completion of 5 years, the junior instructors of UC Burla who have the qualification of diploma will be taken over to the scale of senior instructors. Now, basing on this settlement made in case of UC Burla, the junior teaching assistants of IJT Sarang, who are the present respondents, they made a claim that we have, since we joined in 1991, and by 1996 we have completed 5 years, we should also be taken over to the scale of senior teaching assistants. And they further stated that since there is equality in duties and equality in entry of qualification with junior instructors of UC Burla, we are entitled to get benefit under that settlement. That was their claim. And Lordship, first they approached the government. The government took a decision in the year 2010, Your Lordship, 18 June 2010. What the government decided is that the settlement which is made in case of UC Burla will not be applicable to the employees of teaching assistants of IJT Sarang, and it was further held in the decision that it was the settlement was for a limited purpose and for a specific purpose. The purpose was to merge the pay scales. It was not that it has a universal application and it will be only applicable to UC Burla. This rejection order of the government was under challenge, Your Lordship, in the writ petition. Your Lordship, the relevant observations in the writ petition are at page 79, Annexure 9 at page 79, Your Lordship. May I read that portion?
Yes.
Paragraph 11. Thus, what emerges from the above reference to the settled position of law is that firstly a claim of parity in pay scales based on the doctrine of equal pay for equal work can be validly raised by and considered with reference to employees of two different but associated organizations. Secondly, the claim in order to succeed has to be substantiated by evidence regarding identity in all relevant aspects such as entry qualification, nature of work, pay scales, etc. In this context, it is seen that both UC at the relevant time and IGIT are engineering colleges, and at the relevant time were affiliated to Biju Patnaik University of Technology. It is also seen that post of teaching assistant of IGIT corresponds to post of junior instructor of UC, as would be evident from comparison of their pay scales, qualifications, nature of work, etc. Your Lordship, I would pause here for a minute. The observation that at the relevant time, both UC and IGIT were under Biju Patnaik Institute of Technology is erroneous. Why I am saying, Your Lordship? That in the year 1996, both were under two different universities. Biju Patnaik University of Technology came into existence in the year 2003. So when the first representation was made, they were not associated through BPUT. They were not under BPUT. And when the writ petition was filed in the year 2010, at that time, UC had become an autonomous university. And it was renamed as BSSUT Burla when the writ petition was filed. And these facts were also brought to the notice of the Honorable Court through the counter affidavit filed by the government, Your Lordship. And second thing, Your Lordship, I would submit is, subject to Your Lordship's acceptance, is for giving a higher pay scale to a lower post, there should be similarities in the nature of duties between the lower post and the higher post, Your Lordship. That is what the settled position of law here. And the junior teaching assistant, there is no material provided by the present respondents that junior teaching assistant of IGIT Sarang were performing the similar duties as senior teaching assistants.
Rules are appearing for the other side.
IGIT.
I am appealing for the private of respondent number 1, 2, 3, 4. What my learned friend submitted, this is not totally correct and misleading. Before then, the Lordship may please to have a glance page 2 of the cost title of the writ appeal under consideration. The page 2 of the cost title is the Board of Governors represented to the Director. The Board of Governors neither peruse the judgment, nor consider, nor opine, nor direct authorize the Director. Without an authorization, without a decision or anything, the Director on his own file his application. And to this effect, I will file an affidavit to Lordship or personal appearance may be insisted.
No, we can say it is not valid, we are not properly constituted. Not valid. When there is no. We asked them to file the authorization or the board resolution also.
So did you have the proper authorization to prefer the appeal?
Lordship, IGIT is a government aided college. So government authorized them and authorized the director to file the writ appeal, Your Lordship.
Board of Governors.
I'll submit the letter.
The chairman of the Board of Governors is the
authorization letter, Your Lordship. Director is authorized, Your Lordship. As per bylaw also, director is authorized to represent the institute in all the legal issues.
Institute, but the way you have styled it, he's objecting to that.
The Board of Governors has filed.
Lordship, director is the chairman of the Board of Governors. Your Lordship, director is a member of the Board of Governors, Your Lordship, and they had received the authorization from the government to file the
writ application. He had a principal come secretary, Board of Governors without any comma.
The principal is designated as directors in the meantime of pendency of the case.
So then,
initially it was principal, thereafter same.
So he has filed, the director has filed.
And
so you had arrayed the principal as an opposite party. So you are saying he has been designated as director. So he has filed.
But the point that the Board of Governors never authorized the director. This is my instruction. The Board of Governors who filed the present writ appeal before Your Lordship, Board of Governors never considered the judgment of the Honorable Single Judge, nor director or authorized the director to file the present appeal. But the
so next time, Mr. Counsel, if any appeal is filed on behalf of a state of Odisha, Then can you take this plea that cabinet had not approved? Because there the cabinet is required to approve.
Not in all cases as per the
in all
rules of the
cases.
business, if it is permissible.
Have you filed this an affidavit? That Board of Governors.
Today morning I got the instruction.
You file an affidavit.
Tomorrow I
and if that statement is found to be incorrect, you will proceed against your client for perjury.
As per the instruction, they will submit the affidavit.
You do whatever.
No, you will submit the affidavit that they have not been authorized.
Counsel appearing
Then
on
we
behalf
proceed
of
against
the.
you.
And secondly,
Just a minute. Then counsel appearing on. We have heard that counsel appearing on behalf of the appellant and counsel appearing on behalf of the respondent has submitted that the present inter-court appeal has been filed on behalf of the Board of Governors of Indira Gandhi Institute of Technology, Sarang. But the Board of Governors has never authorized, he has submitted that according to the instruction which he has received from the respondents, the Board of Governor has never authorized the director to file present intra-court appeal. Stop. Next, let an affidavit be filed to the aforesaid effect on behalf of the respondents. Stop. It is made clear that if no such affidavit is filed by the next date, or if such affidavit is filed and the submission advanced on their behalf is found to be incorrect, the court will take appropriate action against the respondents.
Item 8.
You will have to adjourn the matter to
1 week.
counter within 1 week. Okay.
The respondent, you will file.
Yes, ma'am. I am for the respondent 1, 2, 3, 4.
Item 8, sir.
Review petition arising out of writ appeal 1311 of 2022.
This case, complete brief note 41 of the judgment, page 41. Let it come tomorrow, my lord.
No, what is the order?
There is error in para 30, page 35. Last 2 lines. The appellants do not belong to ST or SC category, so they could not claim their appointment against those 257 posts. Yeah. But if you see the member parties, they were in the writ also, writ appeal also, SC candidates. Probably on the statement of Government Council, this has
which paragraph?
Page paragraph 13. One thing.
Where do we get that the SC/ST candidates?
From memo parties, they're SCs, all SCs. And they were parties before writ petition, then writ appeal also. I've given the writ number. They were parties before this honorable court in writ petition also, writ appeal also.
Who?
The present review petitioners.
No, you were the appellants.
I was the appellant.
And you belong to SC/ST category.
Yes, sir.
So how will it change the position? If suppose we accept your submission, then what will happen?
Some of us will get the appointment because under 257, ST were given all the appointments. And this error has come in because para 11, the government council said there were no SC candidates. Eligible candidates were available. Para 11.
So who was ST candidate? Who was ST?
257 seats which were filled were ST.
Which of the appellant was ST?
We are SC, scheduled caste.
SC.
SC.
Who were all of them?
All of them.
Then you could have challenged this order.
But your finding will lead to dismissal of SLP.
No. You can challenge that the finding is incorrect. See, you want us to record that this finding is incorrect. You want us to record that the finding that no person, the appellants are not scheduled caste. You want us to...
the scheduled caste candidates were also available.
But who was scheduled caste candidate?
If you were to see the memo of parties, Alok Mali,
yes,
scheduled caste. He was in writ petition number 27130/2017.
No. Writ appeal.
Writ appeal 1311/2022.
Yes.
Then,
was this stand taken that he was scheduled caste?
Yes, it was.
Where in the writ appeal, where have you stated? Which paragraph?
Writ appeal, I pointed out at the time of judgment, but because he made a statement that there were no eligible candidates as SC, ST,
No, but where have you stated that they should be cast in the writ appeal? Okay.
Where have you writ appeal?
Not even was here. Where in the writ appeal memo, where has it been stated that they are scheduled caste candidates?
Was drafted by him.
Was drafted by? No, but you are arguing for him.
Yes.
So he let him point out then where is it written that they are scheduled caste candidates?
And you should not say that it was drafted by him and it was
You are arguing for
wrongly done by...
Why I am saying, because I pointed out this that some SC candidates are also appellants. But the state council immediately said, no, there were no eligible SC and ST council candidates were available. Therefore, 257 seats went to ST.
So you can challenge that finding.
Well, this is the legal aid matter for me. I challenge this before the Supreme Court.
Yes. How can we? We cannot sit as an appellate authority. We cannot hold that the finding is incorrect unless you demonstrate that there was some material available on record and that...
yes, that can be done because single judge also has pointed out some in his judgment.
What?
That SC/ST candidates were available, but only appointments were given to 257 ST candidates.
But you can challenge the finding of this court. As you wish.
They are not able to come before my lords earlier.
What can we do? Can we,
No, if you point out that
that we can point out from the read appeal.
not responding.
No, that you can find out anything that he had said, "Well, you are not serving."
All right, how do you say that they are not, that they were SC candidates? Only because it was mentioned in the cause title. See, and
No.
Cause title is not mentioned.
Certificates we have deposited in this application.
In this review petition you have given.
Yes.
Not.
that we will not do. That we will not.
Because this.
When did you get the certificate?
This is not a new certificate. This is old certificate, 2005, 2018, 2019. These are old certificates, not.
Page 43.
Yes.
Dated 16/7/2024. Alok Malli. SC certificate 16/7/2024. Akshay Behra dated 15/8/2017.
Yes.
Yes. One is 23. Then the other one.
Then the finding is that no SC candidate was available, eligible.
Eligible.
Yes.
Then
Maybe
they are
available. My lord says appellate
your affidavit you will see.
do not belong to SC or SC, so they could not claim their appointment against those 257 posts.
So accept notice.
Because they went to the tribunal first.
8 weeks. 8 weeks. So they will an AGA to seek instructions and file affidavit. Yes.
Item 33 for today for hearing. None senior counsel is there, and I have also conveyed other counsels to circulation of letter. Absence of and advocate general. May I pray, can it be taken up on 4th or any date, month of December?
This is what?
Regarding that mining matter 12G and 12.
Yes.
This is 31, item 31. Is that sugarcane?
Yes, who?
As your lordship knows. So,
Who else is appearing?
starting shortly, where I'm going to be replying. I'm asking for 31 tomorrow. Can it be in the first 10, tomorrow or day after, either day, the first 10 matters, because that 2 o'clock rule apply tomorrow and day after also. So, your lordship may put it in any first 10 matters, first 7 matters. Tomorrow or day after, whatever.
No, I think this is another matter, but your lordships are hearing mentioning for 23.
23. I don't.
23, yes, Mr. Parity.
Yes, Lord, 23, if they're asking for 3rd or 4th, I don't know what is convenient to all of them. I would only request, my lord, if your lordships can take it up on 4th or 5th month.
Fifth, as jointly requested on behalf of
The same 2 p.m.
parties, discuss matter on these matters on 5th to be.
Grateful. Keep you.
Item 22. There are four matters on board. Let me tell my lord what all these four matters in the not say. What all these four matters are. The first matter, WPC 12305 of 2021 and 12308 of 2020. These two matters, identical prayer. The queries are different. The queries are different. Signed queries are different, but prayer is same.
Can we start? Do we have the permission from the members of the bar to, Mr. Counsel, do we have the permission to begin hearing? Do we have the permission? This is the way you behave in Chief Justice Court. Yes, please.
My lord, I was just telling my lord, there are four matters. Let me briefly tell my lord what these four matters are about. The first two matters, WPC 12305 of 2021, 12308 of 2020. These two matters, the petitioner's prayer, are twofold. Challenging the demand, and the second prayer is he may be allowed to operate the siren for the extended period.
Yes.
Let me make this position clear, Lord. That if your lordship will look at the prayer, in prayer there is mention about a date. The date, if your lordship will see, Lord, I should not sigh out to show my lord's lord. Prayer Roman 2. 21st of May 21 to 21st of May 2023. Your lordship may put me a question that this period is over, therefore this prayer has become infructuous. Definitely your lordship will put me this question. Lord, there with reference to law, Lord, I'll request my lords to, Lord, I'll go to the issue why I am claiming extension 2 years to operate the source, because Lord, I'll take to the little facts. These two matters I am first pursuing, my lord.
So let us see the your prayer first.
Kindly see, Lord, page 24 of 12305 of 2021.
Page
24.
12305.
Right, Lord.
Annexure 1 begins from 26.
Lord, prayer. I am referring to prayer.
Prayer. All right.
Are you not getting that?
Just a minute. Yes, what is your prayer?
Lordship, see, prayer number 1, I am challenging the demand. That is Annexure 3. Prayer number 2, which is relevant, which I am trying.
No, prayer number is quashing the advertisement.
Quashing the advertisement. Yes, I'm so sorry. I'm so sorry. I extremely sorry. Quashing the advertisement for auction relating to this is one is auction, quashing the auction, 2 is quashing the demand, Annexure 10.
Yes.
And it's in the same prayer, there are two things mentioned. Quash the advertisement, then quash the demand.
To execute lease deed.
Right.
In your favor.
Right. To favor the period I have mentioned, yes, which I am saying, Lord, which I will be trying to persuade my lords. The period which I have mentioned, your lordship may put me a question saying that this period is over. So this prayer has become infructuous. Lord, there I will have little submission subject to discretion of my lords. Lord. Here, very short, quickly what I am trying to tell is, 2014-15, a lease deed was executed. Now that lease deed which was executed in my favor subsequently got enhanced in 2016. So far as area is concerned. 2016, another lease deed executed.
For how many? For a year?
Big pardon.
For 1 year?
But lease deed is for 5 years.
For 5 years.
For 5 years.
Yes.
That is 16 executed because they enhanced the area. 2014, whatever area was they allowed us, that was increased by 2016. 2.5 hectares was allowed. Subsequently, it was increased to 6
acres.
6 hectares. 6 hectares. So that is how they executed a press list, 2016. But my humble submission is, these 2 years, I have not been able to operate. After 2016, my client has operated up to 2019. Is this correct?
Yes.
After 2016, pursuant to this revised lease deed, my client has operated the source up to 2019. So from 14 to 16, he wanted extension because there was only simple on the ground that for want of this mining plan approval and environmental clearance, he could not operate this area, despite the fact that substantial payment for these 2 periods he has made. Substantial, barring only 1 lakh some odd rupees, he has paid without having operated the source. Now, this fact your lordship will get from one just document, my lord. Page 48, man.
No, but what do you want? Your prayer is confined to...
Yes, yes, that's what I'm saying. I'm saying. Now, these period, though lease deeds were executed, that's what my submission will be. Though lease deeds were executed, but for want of issuing my mining plan, no lease could have been executed at all. Statute Rule 28-29, if your lordship will see, no lease deed will be executed without a mining plan approval and EC. Those documents, EC was there. Mining plan.
In fact, exactly this point has been discussed by me in one of the cases. 2012, yes, in February, March or something.
Yes, that is one.
Lordship has dealt with this.
No relief can be granted.
I know I'm on a slippery ground. I know I'm on a slippery ground.
We can.
But let I know the position. I'm not
You'll have the chance.
Putting a question to myself, sometimes I am also not convinced. But
that is the advantage of having a fair counsel on the other side.
But that people see the Rule 28 and 29 says no lease deed could have been executed. But right or wrongly, it has been executed. And I am bound by the lease deed. I can't go wriggle out of the lease deed. Lease deed is there. But admitted fact remains that I have not operated. That's their own report. My lifting during that relevant period is 0. That they have reported. If you could kindly see that page over. Page 48 of my report. Annexure facts.
So you must have taken into account all these facts while making your prayer. That is
a mistake they have done. They should not have limited that period. They should have said they may be allowed to operate the source for the extended period. That's all should have been the prayer because they have extended it. In fact, I was just trying to tell my lords, it was ending in 19. Considering this fact that my client has not lifted it, they have extended it. They were gracious, kind enough to extend it for a further period of 2 years. But for the reason, for that period of 2 years, EC was there. Mining approval submission was delayed. Submission of mining approval was delayed. So that is why they have cancelled. My extension has been cancelled. And unfortunately, that cancellation is also not under challenge. That is also not under challenge.
What you were saying, lease is for 5 years. Actually, it is for 3 years.
No, it was 5 years. Because those 2 years we have not been able to operate, they extended it by another 2 years.
2018. Original is for 3 years.
Yes, but 16 is 5 years. 3-2. 14 to 16-2. Then 16-3 becomes 5 years.
No, the lease deed you have given,
Right.
2015-16 to 2018.
3 years, because 14 was there for 2 years. Am I clear? So 5 years period is covered. So these two problems, the delayed submission of mining approval has resulted in cancellation of my extension. That extension cancellation, if your lordship will find, along with that has never been communicated to me. That's even otherwise appealable action. 46 and appeal lines.
Yes.
So that cancellation under rule 46 and appeal lines. And this, I have filed an affidavit that the cancellation was never communicated to me. My client has taken a stand before my lords that it was never communicated to me. He comes to know only from the counter filed before my lords in 2022. 22 counter has been filed.
But even then you did not parent.
Big part.
Even then you
Then also amendment has not been prayed for. Then also that's the position today. This time that's the position.
Oh.
So now your lordship will consider whether I should be given benefit of this 2 years extension period. 1, 2.
We will see.
Two, this non-operational period, whether I should be made liable to pay, because they admit that I have not been able to operate. My lifting quantity is 0. I have not even lifted a 0 grain from this side.
Yes.
My lord, extension of prayer for the mining lease period, my lord. Disputed question of facts, my lord. And the statute also is silent about extension, my lord.
What is the disputed question?
Disputed question, my lord, the reason.
All right, we will see, Mr.
That one more submission. This, so far the first prayer is concerned, challenging the advertisement. Now they have rejected my tender on the ground that I am a defaulter. Those 2 period of due, they have calculated against me and they have claimed that I am a defaulter. If your lordship finds that I am not liable to pay for those 2 crucial years, but because I have not been able to lift it for want of technical this EC and others, I am not liable to pay that. Once that is removed, that tag is removed from me, I am not a defaulter. If I am not a defaulter, then sub-collector will not be correct to declare me a defaulter and debar me from the fresh option. Now, the fresh option, now my Mr. Pradhan's client, one Dori has come up as a successful bidder. Now, if your lordship sees that third writ petition, of course, let me complete my point, then they will have their say. That fourth writ petition, the 3178, kindly see the prayer in the petition. Though I am for the opposite party, petitioner has a right to begin. But let me conclude my part of the statement, man. Kindly see their prayer.
317.
They are asking a relief from my lords. The sub-registrar has refused to register the lease deed in their favor. In the fresh option, they have become the highest bidder. They claim that their deed is submitted before the sub-registrar. Sub-registrar is refusing to register it. That's the prayer here. People lordship see the prayer. Therefore, prayer lordship would be assisted to direct opposite party to execute lease deed and permit petitioner to operate this side. I'm so sorry, bro. It is the prayer is here. I'm so sorry. The prayer is yes. Therefore, lordship may be graciously pleased to admit the petition, issue notice to the opposite party, so cause as to why the petitioner shall not be allowed, after hearing the counsel for the party and considering the cause as shown, if any, allow the petition and issue appropriate nature of writ, passing letter under Annexure 6 to the writ petition. Kindly see Annexure 6.
Which
this is WPC 3178 of 2020.
3178, you read page 6. You were reading page 6, prayer portion.
I'm reading the prayer portion. Should I read it again?
What is this? No, wait a second. This Annexure 7 is ordered it.
But in my brief, corrected as 6. That should be 6. In fact.
Annexure 6, yes.
Yes, Annexure 6, page 30. This is sub-registrar's order.
What is this order?
This is order passed by sub-registrar Aska. He has refused to register the deed. Now, against the refusal of registration of deed, if lordship sees section 72, an appealable action before the registrar. Then also section 77, against the refusal, is civil suit. So this being a limited prayer here, refusing the execution of registration of lease, he has to go in appeal before the registrar. That's all I wanted to tell you.
The first matter WPC 12305. I am appearing for the opposite party number 7. Here the submission was made by my Lord Senior that he has participated pursuant to the fresh auction notice under Annexure 12. My Lord, that is not correct. My Lord, may kindly see my miscase, that is at flag R. IA number 10188 of 2024.
Your number?
10188 of 2024.
In which case?
In the first matter, 12305.
What is that about?
No, we have not participated. I'm sorry. Let me take it. We have never participated in the press auction. No.
No, you made a submission.
Yes.
That because you have been held to be defaulter, therefore you are not being allowed to participate.
Yes, yes.
So you had not participated.
Yes.
Because
no, we have not participated.
So far as the extension is concerned, well, the law has been laid down by this Honorable Court that there is no provision under the OMC 2016 for extension of the lease period beyond the lease period which has been granted under the executed lease. Now, passing on the judgment.
Reference to court.
Relevant paragraphs, paragraph 7 to 11 are the relevant paragraphs. May I place me?
yes.
Paragraph 7, internal page 11. Page numbers are at bottom, right hand side.
But you don't have to refer to any decision. Mr. Bharat has very fairly submitted.
Yes.
That he himself finds it difficult. You are relying on paragraph 11.
7 to 11.
Yes. Yes, and what about your writ petition? You are appearing.
My last rate at mine. That matter 3178.
3178, that order is available. And
Yes, alternative remedies there. I do consider that alternative remedy there. My case, result of my case depends on the fate of the WPC 36487.
All right.
But what happened in that case, 36487. Both the first writ petition, they have challenged the demand notice. He himself filed an affidavit before the Tahsildar. There is no outstanding dues. That's why his bid was rejected on the ground of fraud committed by him. He participated in the bid, submitted false affidavit. There is no outstanding dues. Subsequently, it was detected. Both the writ petitioner and lordship kindly see, they have challenged the demand. That's why his bid was rejected.
So therefore, in third case, his bid was rejected.
So
there are 4 cases.
4 cases.
2 demand notices have been challenged. In third case, what is the...
Third case is perhaps since his bid was rejected, rejection was challenged in the appellate forum.
So therefore, he had participated.
Yes. He participated. After rejection, he went in appeal. Appeal was rejected. Thereafter, challenging the appellate court order, he has filed this writ application.
All right.
But only my prayer, if not that writ application will go, but my writ application will become automatically infectious. But depends on my case, fate of my case depends on the result of writ petition.
Infectious or will be allowed?
Petition.
I mean, you'll be successful.
I am the H2. I am the H2. I liquidated the entire amount. On the day of execution, a communication was sent to the Tahsildar not to execute the lease deed. That is the sole difficulty. That's why it was delayed.
So just because list of dates in all the 4 cases.
That I do. That I do.
Have you given a date yet?
No list of
That
dates
must be
again.
there without relevant date.
We have prepared it. We'll give it. We'll just finish it by.
All of
Yes.
I'm appealing on behalf of Mr. Mahapatra.
I have market suffering from sugar and sugar problem.
This matter hasn't heard.
Okay. So before concluding, my lord, I'll sum up. So far, the first with regard to extension, whatever view your lordship will take, I'll be bound by that. Lordship may consider with regard to waiver of that non-operational period, leave it to the government to decide. Let them take a call on this. If I have not actually operated, I should not be saddled with that.
They might claim other dues like dead rent and all that, because if you have not operated but occupied.
We have already paid.
Okay.
I may ask for refund also. Kindly leave it to the government. Let them take a call on this. So grateful.
These matters for order.
What is the delivery of order?
Orders. For orders. Judgment control. For judgment on.
19th. This will be a judgment.
26.
My lords,
Is it coming in the list again? Will it come again in the list?
No. It will come for judgment on 26.
We'll in the meantime, we'll leave the written note.
I seek my lord's indulgence.
Item note 25.
My lords, item 23, I believe was mentioned with
Your Lordship, I am appearing in
may I mention
WPC number 5794 of 2020.
My lords, I wanted to mention.
I've been told by the other issue involved in my requisition is slightly different from the issue involved in the other requisition. Subject to correction by my learned friends.
My lords, I wanted to
the
mention
issue involved in my requisition
lords,
is on the leviability of the GST on royalty.
So we will leave that. We will decide the such cases today.
Yes.
Which are squarely covered by the Supreme Court's decision.
But I have to distinguish the Supreme Court.
No, therefore your case, we will keep your case aside.
Yes.
We will hear other cases.
Subject to whatever your Lordship may give written proposal.
No, we will decide the first. We will consider the first case first.
Perhaps not subject to your Lordship kind consideration. Obviously, not whatever your Lordship may give written proposal. I have also to address on that issue.
So address.
Then may I start or Mr. Paul?
No. Let us. This is not the way. First, let us take up the first case.
Very well. So great.
My lords, can your lordships hear me? My lords, can my lords hear me?
My lord, in the past case, Mr. Siddharth Rai, senior advocate, was removed, but he has out of station, has gone to Delhi for his health checkup. So,
when do you want?
Next week, any day.
Any after 2 months? Can be fixed. We are getting the orders of stay, interim orders.
Next week, my lord, next week.
Any day. As requested on behalf of the petitioner. WA number, what is this? WA number 432 of 2022.
WPC 3181.
Just a minute.
WPC 3181.
Just
25. Yes.
WPC number 3181 of 2022, as requested on behalf of the petitioner, just this matter on 1 week. Stop. The interim order stands vacated. Yes.
Next.
I mean, pardon, my lord.
My lords, are my lords able?
Next.
My lords, are my lords able to hear me?
Next 23067 of 2022.
Second item also.
WPC 27112 of 2022.
Madam. The challenges in this petition, your objects, with regard to the rate of GST payable on mining visual objects. The period under dispute.
Let us see the Writ petition first. Come to your prayer portion. Where is the Supreme Court's decision? Do you have? Supreme Court's decision you have?
That copy, also scan copy is there. Your Lordship, I have, on the last occasion I have submitted. The scan copy is there, I have.
Scan copy is there.
Your Lordship.
That's the first one.
Page 50, your Lord, 53, your Lordships.
Page
53, my Lord.
53. What is your second prayer?
My Lords. Issue appropriate deed, order, or direction to opposite parties to determine the rate of GST at the rate of 5% on payment of royalty, DMF, and NMT for the period July 2017 to December 2018, as per notification number 11/2017, city rate dated 28th of June.
So, what is the effect of the Supreme Court's decision on this prayer, prayer number 2?
My Lord, it does not impact. Because it does not have impact on these your lordships. Because I am not challenging with regard to levy of duty or whether it is a tax.
Right. So your case is not covered by that.
My Lord.
Learned counsel appearing on behalf of the petitioner has submitted that the present writ application has nothing to do with the decision rendered by the Supreme Court in case of so and so. Yes. So you will not argue. You will not rely on that decision.
Mine.
So I'm appearing through VC Lords in that matter for the CGST department. Lordships can hear me. Lordships, in this matter, the rate of tax is disputing the rate of tax. The issue regarding the rate of tax, my lords, is an appealable order.
So therefore they they'll file prefer appeal.
They'll prefer appeal, my lords. About on my lords.
Prefer appeal against the order.
At the time of admission, their submission, the lack of the submission, my lords.
And the authority of pardon suing already have given the content that the rate of tax is 18%. If I file the appeal, the ultimate result will be the same, and I have to again approach.
That you will do. That the remedy is there.
My Lord, the operator already given the circular of the circular also said it is 18% your lordships. If I delegate me again, I have to come back.
We are very sorry to say that the tendency in the present batch of application is to obtain an interim order and thereafter make every attempt to ensure that the hearing of the cases are delayed. So therefore,
my Lord, can I take a few seconds, your lordships? Only a couple of minutes before my lords. My Lord, the rate notification number 27/2017, your lords.
Can you argue any point in this court which you cannot argue before the appellate court?
I acknowledge before my lords.
Do that.
But it's because the authority of pardons being already given appellate authorities and verdict that the rate of tax will be 18%, and also the circular of the says that is 18%. The ultimate result will be not in my favor, my lord. That's
may not be in your favor. You may challenge that. So what do you want?
With the lordship permission.
Yes.
With the lordship permission. I have an item 25.9, your lordships.
He will take up, sir.
Same point, but I have a slight different point on why alternate remedy. There are 2 points, your lordship. One about the validity of the levy after the judgment of the Supreme Court. That's very interesting. I'll come to it in a minute separately. What we are saying is a notification issued on December 2018, and it says effective from January 2019, statutory notification, increasing the rate from 5 to 18%. They say will apply retrospectively. We are paying tax at 5% at the notification prevailing at that time. A notification which says effective from 1/1/2019 and the rate is 18%. From that day, we are paying 18%. They say this will apply this notification retrospectively, and that too by a circular. And your lordship knows in GST, whenever they want to give the rule making for retrospective effect, section says so. But when it comes to rate of tax, the power is not there. Section says you'll specify the rate from time to time. Obviously, because the lordship rate of tax is retrospectively levied, I would have sold the goods, etc. Therefore, Parliament never gave the power to this rate fixing authority to issue notification retrospectively. Plus, the notification specifically is effective for 1st January 2019 by circular issued in 2021. Saying our circular is retrospective, the notification is retrospective. We are concerned with that point only.
We will take up your matter.
Only on retrospectivity we are. Therefore, we said lordship need not delegate it. That's the only point, lordship.
Yes.
I'm grateful to lordship. My apologies.
Whether you
my lord,
has been argued.
Yes, my lord.
Should we hear him first?
Yes, my lord.
Should we hear him first?
My lord.
All right. Yes, Mr.
Grateful, lordship. Yes, put me on the opening batsman. Always risky, lordship. You can either score a century or you can get out.
Yes. Which item?
Mine is item number 25-9, your lordship. Petition 12263. Tharani metals, your lordship.
This is 4.
25.9, item 25.9.
12263.
Lordship, 12263. With the lordship's permission.
Yes.
Very briefly, your lordships. We have on lease a mining ore permission, your lordship, from the state authorities. Okay. We do mining of the ore. We pay royalty to the government, your lordship. Normally, your lordships are aware, service tax is GST is to be paid by the person who provides the service. Seller of the goods has to pay GST, or supplier of service has to pay GST. But when the GST is paid by the government says we will collect it from the purchaser. They don't want to file registration, etc. In a light revenue lordship, I used to joke. The chief minister visits Kolhapur during election time, and he tells the farmer, "I'll abolish sales tax on sugarcane." Okay. Then he'll come to the state secretariat. The revenue secretary will say, "Sir, we are collecting 5,000 crores sales tax on sugarcane. We abolished. What do I do? Where will I go for 5,000 crores?" The chief minister says, "That is your headache." Then the revenue secretary tells the chief minister, "Sir, shall I put purchase tax on the sugar mills who will consume the sugarcane?" Okay. The chief minister says, "Good job done. I am collecting 5,000 and I have told the farmers I will not collect." So if it is collected as sales tax, it is called as, if it is collected for the seller, they call it as sales tax.
Same thing.
If they collect it for the purchase, they collect purchase tax. Similarly, lordships, GST, when it is paid with the supplier, normally that's the rule. Sometimes the lords, they collect from the receiver. When lawyers were subject to GST, lordships, the powerful lawyers lobby went to the government and said, "Please don't levy GST on us. Collect the same GST from our clients." Legal services, your lordships, GST is collected from the recipient of service.
Yes.
So similarly, your lordships, in pursuit of mining, the supply is made by the government by granting right to mine. Ordinarily, they have to pay GST, but the law specifically says we collect it from the recipient. What we technically call reverse charge mechanism. Instead of normal charge mechanism from the supplier, they collect from reverse charge mechanism. During the period in question, your lordship, they issued a rate notification in terms of Section 9, according to us, fixing a rate of 5% as a tax rate on this supply, which we have paid also. We paid also, lordship, because and the entry says whatever rate is applicable to the underlying goods, that will apply for lease also. For example, lordships, if sale of photocopiers also attract 18% GST. If computers attract 5% GST, lease of computers also should attract 5% GST. So iron ore, your lordships, around in a minute, iron ore attracted 5% GST. Therefore, the note says leasing of iron ore also will attract 5% GST. That's what the notification is. We have paid that. Subsequently, in January 2019, increase in the rate of tax from 5 to 18%. For whatever reason, lordship, and we are paying 18% prospectively. The whole question, therefore, is whether a notification prescribing a rate of tax of 18% and the notification expressly saying effective from 1/1/2019, can it be applied for the past? The government issued a circular in 2021 saying there were some errors in our language of the notification. Our intention is always to charge 18%, and therefore we will charge you 18% for the back period. That's the contention, Lordships.
Where is that notification?
I'll show that in a minute, Lordships. Unconnected incidentally with this, Lordships, we say the whole exercise is an exercise in futility, revenue neutrality, as we call it, Lordships.
Where is the notification?
Lordship. The notification is, Lordship, in the writ petition at page 105, your Lordships. That's a short point. Your Lordship comes to page 105 in the writ petition.
105 is dated 31/12/2018.
Grateful, Your Lordship. Highly obliged. Highly obliged. If Your Lordship kindly come to page 107, last line in that page, serial number 2. This notification shall come into force from 1st January 2019. Your Lordship has got that? Honorable my Lord, the Chief Justice. 107, Your Lordship. Of the writ petition. Last line in the end of the notification. This notification shall come into force on 1st January 2019. Lordship has got that?
Yes.
So the notification is dated 31st December 2018 to be effective from 1st January 2019.
Yes.
They want to apply this for the past period. Admittedly, after January 19, we are paying the tax, we are no problem. So Lordship sees page 106.
Yes.
Item E. (7)(a) is the amended entry. Leasing or renting of goods, same rate of central tax as applicable on supply of like goods involving transfer of title in goods. The Lordship's permission, I may permit to read again.
Yes.
Leasing or renting of goods, the rate of tax should be what? Same rate of central tax applicable on supply of like goods involving transfer of title in goods. At page 106, para E, Lordship. Lordship has got that?
Yes. Yes, we have seen.
What it means is, if sale of computer attract 5% GST, lease of computer also attract 5% GST. If sale of photocopiers attract 18% GST, lease of photocopies attract 18% GST. That's what entry 7A is. And 8 is leasing or rental services with or without operator other than 1, 2, 3, 4, 5, 6 and 7A above. That is 9%. 9% CGST, 9% SGST, total 18%. So on or after 1st January 2019, mine will be covered by serial number 8, because when you take mine on lease, there is no goods involved. Goods will be when the ore is extracted, that will become goods, but during mining it is not goods. So post 2019, the entry 7A is confined to leasing or renting of goods. And the example I gave, Lordship, lease of photocopier, computer, etc. Post 2019, I will follow the serial number 8 at 9% CGST, 9% SGST. We are paying that. We have no problem. For the past period, they want to apply this entry. Our submission is under section 9 of the and this is a rate notification. Under section 9 of the CGST Act, you don't have power to issue notification retrospectively. And the Lordship knows. I feel little hesitant, the Lordship, place where my Lord the Chief Justice. Ordinarily, subordinate legislation can never be retrospective unless the parent legislation confers that power expressly. Parliament can make laws retrospectively. Subordinate legislation can never be retrospective. Kindly look at section 9, Your Lordships.
Yes.
The rate of tax will be.
Yes.
9(1).
Just a minute.
Section 9(1) of CGST Act.
Yes.
Subject to provisions of subsection 2, there shall be levied a tax called the Central Goods and Service Tax on all intrastate supply of goods or services both.
Yes.
Except 9(1), Your Lordship.
Yes.
Except on the supply of alcoholic liquor for human consumption on the value determined under Section 15, and at such rates not exceeding 20%, as may be notified by the government on the recommendation of the council, and collected in such manner as may be prescribed, and shall be paid by the taxable person. With the Lordship permission, omitting unnecessary words, there shall be levied a tax called CGST on all intrastate supply of goods at a rate not exceeding 25%, as may be notified by the government. So the rate will be as notified by the government, Section 9(1). The notification as issued in July 17 notified 5% for me, 2.5% CGST, 2.5% SGST. Notification of 1st January 2019 notified 9% plus 9%, 18%. They wanted to apply retrospectively. According to them, we made a mistake in the earlier notification. According to them, our intention is always to collect 18%.
So where is that according to them that they had committed mistakes?
Lordship, kindly see the notification at page 79, Your Lordships. Serial number 17.
Yes.
And we have paid tax under that entry. At page, Your Lordships, page 86.
Yes.
The Lordship kindly come to item number 6 at page 87 of serial number 7.
Page 86, serial number
17, Your Lordships.
17, yes.
This is a notification issued under Section 9(1) on 1st July 2017, prescribing the rate of tax. And if Your Lordship kindly come to page 87, serial number 6. Leasing or rental services with or without operator other than 1, 2, 3, 4, and 5 above. Mine is leasing, mining lease from the state government to me. Okay. Rate of tax, same rate of central tax as applicable on supply of like goods involving transfer of title in goods. My iron ore rate of tax is 5%. So when I mine the iron ore by way of leasing, I pay the same rate as 5%.
Where is that, Mr.?
At page 87, Your Lordship, item number 6.
87, sorry.
87, my apologies, Your Lordship. Small item number 6.
Item number?
Sub item number 6 in serial number 17. My apologies, Your Lordship. Leasing or rental services with or without operator other than 1, 2, 3, 4, and 5 above. I'm not covered by 1, 2, 3, 4, 5. I'm covered by leasing because government of Orissa has given me mining leases. So it's a leasing service by the Orissa government to me. I have to pay tax on that. What's the rate of tax? Same rate of central tax as applicable on supply of like goods involving transfer of title in goods. So if you mine a copper ore and the rate of tax on copper is 18%, the lease of mining rights on copper is 18%. So if you are mining and taking gold and rate of GST on gold is 10%, your leasing of mining for gold is also 10%. In my case, Your Lordship, I mine iron ore. Iron ore rate of tax is 5%, no dispute. So on the leasing services provided by state of Maharashtra, state of Orissa to me, in terms of 17.6, I paid 5%. They say no, you now pay by the January notification. Kindly come to page 106 again, your lordships. They carried out an amendment at page 106 again.
That's at 105.
Lordship, 7A, lordship. Your lordship.
106.
Lordship, yes.
Yes.
It got 6 became 7 somewhere later. We need not bother. But 7A, leasing or renting of goods, same rate of central tax as applicable on supply of like goods involving transfer of title to goods. The earlier notification at page 87 simply said leasing or rental services. The notification of January 19 says leasing or renting of goods. Okay. So, my apologies, lordships. The January 19 notification says leasing or renting of goods, same rate as applicable to the main sale of goods. So, we take a computer on lease, rate of tax is 5%, if sale of computer is 5%. So, post January 19, the entry specifically says leasing or renting of goods. And serial number 8 says all other rental services 18%. Whereas at page 87, which with I am concerned, it did not use the word leasing or rental service of goods. If you kindly come to page 87. Leasing or rental services. So they bifurcated from January 19 into 2 categories. Leasing of goods, other leasing services. Page 87.
Yes.
Earlier entry covered leasing or rental services. Now leasing of goods, 1 rate, all other rental leasing 18%. And this notification, lordship, obviously is prospective. Notification says is effective 1st January 19. Section 9(1), they don't have power to issue notification retrospectively. And I have collected this tax and I paid this also. That's a short point of lordship. I want to explain to lordship in further detail why they give a stretched reason that it is retrospective. I can go to your lordship on that. But my first submission is whatever laudable, however laudable your objective may be. Okay. If you don't have power, you don't have power.
That was actually serial 6.
Lord, 6 got renumbered as 7 sometime later, lordship. We need not bother about it.
7 or 8? 7A. Okay, 7.
It got renumbered as 7A.
2017 6.
If your lordship sees page 95,
yes,
6 got renumbered as 7 at page 95. I didn't want to trouble your lordship. In October 17, what your lordship sees at page 87 is 17.6 as introduced in July 17. It got renumbered as 7 at page 95. And then it was made into 78 at page 106. Your lordship is right.
Yes.
6 became 7. So our limited submission, therefore, your lordship is, in these circumstances, the claim of the circular issued by the central government that this notification of January 19 will be effective from July 17 is plainly illegal.
Where is that notification?
The circular, your lordship. It's an administrative
circular. Where is the circular?
I'll show that, your lordship, in a minute. Lordship, I have my junior will hand over a compilation to lordships.
Already handed. Which page?
Page 5, your lordships. At page 7, para 9. At page 7, para 9, your lordship has got that. The circular starts at page 5 of the compilation. Circular 6th October 2021.
Yes.
Page 7, para 9.
Yes.
With the lordship's kind permission, can I read it to the lordships?
Please.
Services by way of grant of mineral exploration and mining rights. Representations have been received requesting for clarification as to the rate of GST applicable on supply of services by way of granting mineral exploration and mining rights during the period July 17 to December 18. With effect from 1/1/2019, the rate schedule has been specifically amended and is undisputed since then that such services attract GST at the rate of 18%. For the disputed period, before I read the Lordship lighter vein, in the House of Commons, I am told the Lordship, the opposition asked, government, you are appointing a commission of inquiry, will you be bound by it? The leader of the House said, yes, provided it is in our favor. I don't know why these people went and asked for representation and invited trouble for themselves. For the disputed period, that is July 17 to December 18, divergent rulings have been issued by authorities for advanced ruling and appellate authorities for advanced ruling of various states on the GST rate applicable on the same. Advanced Authority Haryana, in the case of Pioneer Partners, and Advanced Authority Chhattisgarh, in the case of NMDC, have ruled that service of granting of mining leases is classifiable under Service Code 997337, licensing services for right to use minerals, including exploration and evaluation, and attracted prior to 1/1/2019 the same rate of GST as applicable to minerals, that is 5% as prescribed under serial number 17, item 7 of notification 11 of 2017. The rate prescribed against entry prior to 1/1/2019, the same rate as applicable on supply of like goods involving transfer of title in goods. In certain other advanced rulings, a view has been taken the grant of rights for mineral exploration and mining would be covered by 9991 and attract GST at the rate of 18%. Appellate Authority for Advanced Ruling Odisha, on the other hand, while ordered dated 5th November 2019, in the case of Penguin Trades, held that grant of mining lease was taxable at 18% prior to 1/1/2019. Appellate Authority, in this case, observed that GST rate applicable against serial number 17, item 7 of notification number so-and-so was not implementable. Kindly note this very word, Lordship. This note, serial number 17, item 8 was not implementable. Unlike leasing or renting of goods, there were no underlying goods in the case of leasing of mining area. The rate prescribed for goods cannot be made applicable to leasing of mining area which confers the right to extract and appropriate minerals. Mining lease by government, not being lease of any goods, cannot attract rate applicable to sale of like goods. Appellate Authority for Advanced Ruling Orissa had further held the amendment carried out by notification 27/2018 dated 31st December 2018, which restricted the same rate as applicable to supply of goods involving transfer of title in goods only to leasing and renting of goods, was to clarify the legislative intent as well as to resolve the unintended interpretation. It is settled law that interpretation which defeats the intention of legislature cannot be adopted. It accordingly upheld licensing services for the right to use minerals, including its exploration and evaluation, falling under Service Code 999737, was taxable 18% during the period July 17 to December 18. It may be noted that the expression same rate of tax as applicable on supply of like goods involving transfer of title in goods applies in case of leasing or renting of goods. In case of grant of mining rights, there is no leasing or renting of goods. Hence, said entry does not extend to grant of mining rights, which is an entirely different activity. The issue was placed for GST Council in 41st minute on 17/9/2021. As regards classification services recommended by the Council that service by a grant of mineral exploration rights most appropriately fall under 99/73/37 licensing services for right to use minerals, including the exploration and evaluation. As regards applicable period from July 17 to 18, Council took note of the following facts. GST Council in 4th meeting held on 3rd November 16 decided that supplier services should be generally taxed at 18%. More importantly, GST Council in 14th minute held on 18th and 19th May 2019 will recommend the rate schedule of services 5, 12, 18 and 28 specifically recommended that all the residential services would attract GST at the rate of 18%. Rate applicable on the service of grant of mineral exploration lines and mining lease under service tax was also standard rate of 15.5%. Services under this category have been standard rated in GST at 18%. Therefore, intention has always been to tax this activity oblique supply a standard rate of 18%. Accordingly, as recommended by the Council, it is clarified that even if the rate schedule did not specifically mention service by of granting of mining rights during the period July 17 to December 18, it was taxable at 18% in view of the principle laid down in 14th meeting of Council for residual GST rate. Post January 1919, no dispute remains as stated above.
So whether this circular is under challenge in any of
Yes,
the...
Your Lordship, yes. It's a specific challenge.
Where is that?
Our problem is created by the circular, Your Lordship.
Circular is under challenge.
Lordship, yes.
I don't think.
Lordship, sir.
In this case, I think only the notification 11 of 2017 has been under challenge. The circular is not in challenge.
That circular is not under challenge, Mr. Student.
Lordship, please kindly come to page Govardhan Das. Govardhan Das. Your Lordship, with respect, perhaps is right, but page 57, para 3. A specific case is that for this period I am liable at 5% only. There's no dispute about that. That's our case. Whole passage is this.
That point can be raised in any other writ application, but not in this.
Page 57, para 3, Your Lordships.
Page, yes, this is different.
Issue appropriate rights to hold the order of appellate authority is not appellate patient. Observation of appellate authority that notification is clarification.
Notification of 2018. This is
2B and C.
This is 2021.
1, 2, 2, 3 of Parity Minerals, 122 of 63 of 2023. That's the writ petition. At page 57, para 3, Your Lordship.
No, you are referring to the circular dated 6/10/2020.
Lordship, yes, Your Lordship, yes. Right.
This is not under challenge.
There is no expressly, Your Lordship, in the prayer, but I thought this prayer is good enough to cover that. I can formally amend it, Your Lordship. My case has been in the petition that I am liable to pay 5%. It cannot be retrospective. Specifically. And they, in their counter also, they relied on the circular. Circular, Your Lordship, if it's contrary to law, it goes.
See, there are two aspects.
Lordship, yes.
If without this notification, some demand notice has been issued, then you have the remedy of appeal.
Oh, they have relied on this, Your Lordship. They have relied on this circular of 2021 to hold against me. The whole provocation is because of the circular of 2021.
No, where is that?
In the impugn order, they rely on the circular, Your Lordship. In the impugn order.
Where is the impugn order?
Page 191 to 239.
Page?
191. It starts at page 191, the impugn order. At page 225, para 9, Your Lordships. at page 225, para 9. The Lordship has got that? Page 225 of the writ petition, para 9 of the impugn order, internal page 35 of the impugn order.
Yes.
A circular is there, whole case is against me based on the circular. And circular issued 2 years after the notification of 2019. With respect and humility, your Lordship's observation, the attempt is to get an interim order based on some challenge and the petition to take it get adjourned. That is correct. I don't want to do that. That is unfair also. Totally. Your Lordship also traveled in the bar only. Your Lordship knows all the tricks of the bar. But, Lordship, there is a question of rate of tax being increased retrospectively when there is no such power under the Act and the notification says effective from January 19. Page 225. That's the sole basis of the Lordship. The provocation is the circular.
Yes, how do you justify that?
And I just one sentence, Your Lordships. We say revenue neutral. This is the worst form of revenue neutrality. I'll tell you, Your Lordships. Suppose I have to pay output tax of 100 rupees to the government in cash. Right? I pay on my input 60 rupees. Then I pay 60 rupees in cash on the input, 40 rupees in the output. And government gets 100 rupees in that month. And I paid that. Subsequently, they say, no, on input, you should not have paid 60, you should have paid 70. How does it make a difference? All you do it in a statistical delight. In your statistical board, you will say, I collected 30 rupees output tax from the assessee and 70 as input tax from the assessee. Absolutely not even 1 rupee difference to the state or to anybody in the same month also. There is no deferment of tax, etc. Because the Lordship's input credit, I pay and take credit and pay the balance in cash. If you increase this or that, absolutely no difference. So our submission, therefore, Lordships, and the AAIR notes that your earlier entry at 5% is unimplementable. My junior is younger, Lordship, and bold. He says, unimplementable means I need not pay any tax at all. That you please argue. He said, argue for the Honorable Chief Justice if there is no rate specified by me at all. So I need not have paid 5%. I said, since that's it. The contention is the entry as president is 5% is unimplementable because it says leasing services rate applicable to goods. In case you take on lease of mine, it's immovable property, no rate is for goods applicable. If not implemented, no tax at all. But we paid 5%, which is the rate applicable to the concerned goods. Okay.
Yes.
And there's no power, Your Lordship. However, however laudable their objective is, there's no power. There's no question of clarificatory. This is the point we want to say.
This issue, so far as the circular number 64 of 20, as duly considered by the adjudicating authority, Your Lordship, by right image in place 2 to 5 pace.
I don't know how this can be made retrospective. That is the only question.
In addition to that, Lord, I can show it from the circular which has been placed before Lordship now. Lord, kindly Lord, see the circular what is placed before Lordship 9.3.2 italic 1. In addition to that, even if retrospective may not be applicable so far as accepting sometime the condition of my senior, Your Lordship see the council meeting regulation and the board meeting of 2016. That suppliers, Lordship see the
just
9.32.
Yeah.
3.2, Lordship, the page 7 of the circular the handed over to Your Lordship just now.
Yeah.
Competition.
Yes.
But the heading is as regard the applicable rate from the period 7 of 2017 to 31/12/2018. That is not whole issue here. The council took note the following facts, namely the GST Council in its 4th meeting held on 3rd and 4th November 2016. Kindly mark them not here. Had decided that supplier service generally taxed at 8%, 18%. Therefore, assuming My seniors not say this, even if it is not retrospective, but these will be applicable because the 18% has been fixed in the year 2016.
Very good. So the GST Council had fixed this in the fourth meeting.
Yes.
So who knew about it?
No, that is in the rate. That is in the rate chart. But the rate chart has been fixed in this in not the notification. It doesn't mention. These issues has been earlier. Not. It is not in 2017 or 21. It was in the 2016.
The 9.3.3.
Yes. The rate applicable to service grant mineral.
Accordingly, as recommended by the council, it is clarified that even if the rate schedule did not specifically mention the service,
during the tax 18 by in view of the principle laid down the 14th meeting of council for the residual GST part post January 2019, no dispute remaining stated above.
So whether this rate was notified?
Rate was not at 5%. When the statutory notification is issued, what they are saying is there's a disconnect between my statutory notification issued under Section 9. There I specified 5%. And what I thought.
The GST might have taken some decision, GST Council.
Yes.
But the question is whether the decision of the council was notified.
Yes.
And when translated to statutory notification, it was 5%. Now what they are saying is my notification is slightly defective. It is not in conformity with what I recommended. Okay. We are concerned with the recommendation or the notification statutorily issued. And there also there are flaws, even on the recommendation.
He has a point. He has a point that GST Council might have taken some decision. But whether that decision of the council was translated into statutory notification, that is the only question, I think.
Absolutely, I'm grateful to the Lordship. I'm grateful.
But all the services, not it has been notified as the not 18%. Then here is a service, not.
Where?
It has been not in the notification not will be.
Prior to 2019.
Yes, Lord, I'm just not.
None.
2000.
They say the peak rate of service tax should be 18%. What the council said is peak rate will be 18%. Within that, you can have lower rate. That's what it is. They say don't go beyond 18. Therefore, but in my notification, statutory issued under Section 9(1) and serial number 6 or number 7, they say that as the goods.
Let him complete, Mr. Yes.
Let's see page 78 of the brief note. Brief of the
Writ petition.
Yes.
Annexure 1.
This is not
that same notification.
Yes. There is a notification. Start from page 59. You Lordship kindly see Lord page 78 for a moment.
We had seen.
Yes, Lord. There is a group, and the group code is 99979. Lord, the next the other miscellaneous service.
78.
Page 78.
Page
78.
Yes.
Lord,
which item?
Starts from 716 and Lordship see this 722 now. The code is 99979. Other service nowhere else specified now.
It is no. It was nowhere specified.
The residual.
So there was ambiguity.
No. See, if there was any ambiguity, then even then the benefit will go to.
Your Lordship, so far as the ambiguity is concerned.
No. There is no question of ambiguity. Whether the service was not specifically mentioned in this.
No, Lordship, that what my Lawrence Senior has that 99737 has shown, your Lordship, so far as the same rate as central tax is concerned. There it was service. Your Lordship, there was no segregation in between service, supply of service and supply of goods till 31st 12/2018, your Lordship. Your Lordship, since that has not been in 14th GST Council meeting, your Lordship, it has been decided that all the services are to be taxed at the rate of 18%. Your Lordship, so far as the GST Act, your Lordship, I may be permitted to show some of the provisions, your Lordship. From all these provisions, this service can be treated as a supply of service. There is no supply of goods.
So once it has been supply of service, so it cannot be taxed at the same rate on supply of goods. Your Lordship, supply of goods and supply of service, there are two different categories, Your Lordship. And from the very beginning of inception of the statute, inception of the GST Act, Your Lordship, as per Article 279A of the Constitution of India, so far as the formation of GST Council, and GST Council from different meetings, it has been categorically held that it cannot be reduced from 18%. So inherently from all these aspects, from Mines and Mineral Act and as well as GST Act different provision, it is service. Your Lordship, I may be permitted to show, Your Lordship, some of the provisions so far as the GST Act is concerned. Your Lordship, what is the definition of service and what is the supply of service and how this is a supply of service? Your Lordship, may kindly look in.
Just a minute.
Your Lordship.
So you are relying on which entry?
Your Lordship, we are relying on that 997, that proof that nowhere else is prescribed, Your Lordship. Services provided, Your Lordship, other services, Your Lordship.
997?
Your Lordship, 997.
997.
Your Lordship, other services, so far as the other services. Why, Your Lordship, what is the intention, Your Lordship, with great respect? Why I'm submitting?
Just a minute, 997?
Of 28/6/2017 notification.
So page 78.
Page, Your Lordship, page
70. 70 is what?
78.
Yes, ma'am.
78 a group printer, 91.
997 and then what? 99799.
99799. Other services are classified. Mr. Mishra, that's serial number 722. Page 78, serial number 722.
Lordship, may kindly look at page 65, 232.
That is the grouping.
We are trying to appreciate, Mr.
That is the grouping. And so far as the entry is concerned, that is that pays that rate of 9%. Page 86, Your Lordship. Page 91, Your Lordship. Why?
Just a minute. Just. And Mr. Sridharan, if we are not incorrect, you are referring to heading 9973.
Lordship, my lord, the Chief Justice knows everything. There is no need for a counsel. Page 65, serial number 232, Your Lordships.
65.
That's where they are assessing me even today. What my learned friend showed is residuary entry.
65 heading?
serial number 232, 9973, leasing and rental services. Their own circular says you are under 9973.
Leasing or rental services.
Lordship, yes. Post 19 also they're putting me under this. Post 19 also they're putting under.
Whether it is clear that this expression mining lease is not there anywhere in the list.
No, Lordship, mining is also here in this. Lordship, just 1 minute. They're putting me 999737 specifically. Lordship, yes.
257. Probably that's at page 66.
Page 66.
Serial
Page
number-
66.
Serial number 257.
Not 257.
I'm sorry.
Licensing services.
Lordship, yes, licensing services.
Not leasing, licensing services.
That's where they are putting your Lordship.
Licensing.
Lordship, you're 100% right. In law, there's a difference between leasing and licensing, but GST people mix up all that.
This
And this is under title of leasing.
Not 99, not serial 249.
that is the conferment of right.
Okay.
That is the conferment of right. So the service is
Leasing or rental services.
since it has been bifurcated in sale of goods and supply of goods and supply in 2018, so there was ambiguity.
But if you refer to 257,
Your Lordship,
it is under the grouping
997337. Only that is conferment of right. That
right
is
to
the
use
conferment.
intellectual property and similar products. That is the main heading.
Your Lordship, I'm not disputing so press that since
See, 257 will have no application. 257, Mr. Srinathan,
Lordship, yes.
we don't think.
Lord.
257 at 66.
Lordship,
There
yes.
is no application because it says licensing services
Lordship, yes.
for the right to use minerals,
Lordship, yes.
including its exploration and evaluation.
Lordship, yes.
So this 257,
that is only conferment of right. So far as right to use minerals.
whatever, this entry will not cover this.
Lordship, your Lordship is right. I just want to make one small submission. This chart at page 59 to 78 is irrelevant to this controversy. That's a list of services. It doesn't specify rate at all.
No, yes.
It is enumerating the list of services. The rate notification is at page 79. And according to the circular of 2021, I fall 9973. Even pre-19, post-19, they accept 9973. The demand notice issued 9973. For 9973, rate was 5% prior to January 19. It was increased to 18% post-19.
So you will have to confine your submissions to 9973. All right, we will examine that.
Your Lordship is
Proceed from there.
Your Lordship is absolutely right. Only Your Lordship is only what that entry is the conferment of right. There was ambiguity. Why, Your Lordship? Because Your Lordship may look into that circular of 2017 on 31st 12 2018. In the first circular and the subsequent amendment also, that is the entry was only that entry was leasing and rental services with or without operation. Now, why there was ambiguity, why it has been treated as retrospective by GST Council, Your Lordship. In 2018, there was a bifurcation. Your Lordship, bifurcation in 2018 amendment, leasing and renting of goods. Your Lordship, actually, in fact, I have...
The dispute relates to which period?
This is both periods are here. So the both periods, pre-amendment, post-amendment, both periods are here.
Only pre-amendment, Lordship. Entire there is pre-amendment. July 17 to December 18.
Answer.
This 1/7/2017 to 31/12/2018
This case
is the disputed period.
After 31st June 2018, there is no dispute so far as the rate is concerned. Only levies, your lordship, to decide. So my respectful submission before your lordship is that why there was ambiguity? Your lordship, let me try to convince your lordship. In 2018, 31st December 2018, the circular, there was a bifurcation. Leasing or renting of goods, and leasing and rental with or without operator service. So goods, supply of goods and supply of service, that bifurcation was not there in the notification of 2017. So in 40th GST Council meeting as well as 4th GST Council meeting, your lordship, it has been categorically decided as per the power conferred under Article 279A by the GST Council. The GST Council has decided all of the residual supply will be taxed at the rate of 18%.
Let us see which provision you are referring to.
Your lordship, I am referring to Article 279A of the Constitution of India so far as the GST, formation of GST Council.
Yeah, are you referring to that constitution?
Your lordship, I'm sorry, I just want to.
Yeah.
279A. The President shall within 60 days from the date of commencement of the Constitution, act by order constitute council to be called GST Council. The GST Council constitutes the following so and so, your lordship. The member of GST Council referred to in clause shall as soon as made.
No, read the relevant part.
Your lordship, this GST Council will further law. So regarding GST, goods and service tax.
You are relying on which part of this?
Your lordship, the Goods and Service Tax Council shall make recommendation to the union and the states on the taxes.
All right. Anything else apart from recommendation?
Your lordship. Now, your lordship, taxes, cesses, and surcharges levied to the union, state, local bodies which may be subsumed in goods. The goods may be subject to exempt from the goods service tax. So all these recommendations the GST Council has to make. So accordingly, GST Council has made the recommendation in 14th GST. I'm sorry that minute I don't have.
No, see. Is this your submission that the recommendations of GST Council are binding?
Not particularly that, because Honorable Supreme Court in some of the cases
some of the cases, no recommendation is binding. Recommendation is always recommendation.
Not what I am well aware. So, what my submission? This is a service. So, when this is a service, and there was no bifurcation in 2017 goods and service, and the bifurcation came in 2018, 31st April 2018.
Where is that? Let us see.
2018 notification is there.
That's the one, 1st January 19.
By amendment?
Lordship, 31st December 18.
My lawrence,
let us see.
Page 105.
Page 105.
Bifurcation?
Bifurcation in the notification.
In the notification, what is that?
Your lordship may kindly look into the brief 106. Page 106.
Yes. That is what we were reading.
Annexure 5, your lordship. Annexure 5 start from 105.
Yes.
106 is the relevant portion. E. Subclause E.
Yes.
Leasing or renting of goods. This is same rate of central tax as applicable on supply of like goods involving transfer
So
of
he is
tax.
relying on that.
That's it. I'm also relying the same. Why I am relying? Here there is a bifurcation goods, same rate, and service 9%. Before that, in 2017, what my lawrence senior has shown, when there was supply of service. Supply of service in that. But if I'm sorry, this is not I'm Proforma party, I'm party in the first grid.
Page 87, sir. Page 87.
So 9973, that is page 86. Page 87. Page 87, you kindly look into for a moment.
You have to decide on this one. Yes.
Page 87, Your Lordship, Roman 6, leasing a rental services with or without operator other than 1, 2, 3, 4, and 5. Same rate of central tax is applicable on supply of light goods involving transfer of title and goods. So, Your Lordship, here there is no bifurcation of goods and service.
Then?
So, goods rate is at 5%. So, supply, all the supplies are 18%. So, there is ambiguity whether it is a supply, I'm sorry.
So, if you cleared that ambiguity, you could have done that prospectively. How?
Ambiguity has been treated by you. So,
Yes.
Oh, Your Lordship, and also, Your Lordship, in the first case, I have filed the counter.
See how clear is this notification. Just
Yeah, Lordship.
it specifically mentions the rate.
Your Lordship.
See, leasing or rental services.
Your Lordship.
So service is mentioned
Your Lordship.
with or without operator.
Your Lordship.
And then it says same rate of central tax as applicable on supply of like goods involving transfer of title in goods. So there was the provision was absolutely clear. It was absolutely clear. How can you and this cannot be interpreted in any other manner.
Your Lordship might have remembered long ago, Your Lordship has asked my personal opinion. So far as
Yes, don't give here.
Your Lordship, I have given opinion that 5% will be justified.
Yes.
So, Your Lordship, only I rely on my counter.
Yes.
Your Lordship, in not particularly in this case, in the first case, I have filed the counter. In the first case, I am appearing, I'm the answering party in the first case. So that counter I may be permitted.
Lordship, so far as here, Lord, I am the agreed party so far as the opinion. Your Lordship, my request.
Just a minute. So that is over, Mr. On the record. Yes, fair enough.
Lordship, may record my.
I am 27112.
So my contention, Lordship, I have filed a counter.
You are appearing for whom?
I am appearing to
Appearing in this case for opposite party number, but from the state GST, in all the cases I am appearing as the standing counsel of the state GST. In some of the cases, I am the answering party because my officer has passed the order. And in some of the cases, I am as pro forma party because I am appearing on behalf of the state GST. So far as the first case is concerned, which Your Lordship has backed the stay order, in that case, I have filed the counter and I rely that
so we will recall that order.
I rely on that counter in all the cases, Your Lordship.
Yes.
Lord, I am appearing in this case, Lord, 3, 5, and 5, 3, 5, and 2, 9. 3 and 5, 2, 9.
You are representing whom? You are representing whom?
Lord, I am representing Central GST. CGST.
The Lord says I may permitted to comment. My Lord says I'm in WPC 27112. I'm appearing for Central GST. Lord says to supplement the submissions of.
We will hear you. We will hear you. We are not in hurry.
Lord,
Your Lordship, here I file a counter. In this counter, kindly see page 21.
So, what is
what I stated that Your Lordship is requesting Your Lordship that kindly you are taking consider this amendment made in the counter appeal. Not in Lordship passed. I don't have trouble, Your Lordship. Page 21, 25.6 para.
CA? Paragraph?
Paragraph, page 21 of my counter affidavit. Paragraph 25.6 starts here. That is relevant to 25.6.
Yes.
Page 25 ended hence 25 before paragraph 9. That is my solvents after the
in WBC?
This case, but my sheet is not.
You are reading which paragraph?
Para 8 of subparagraph 25.6 starts.
Para 8.
8 of subpara 25.6.
2 will end.
Okay.
End is not 20, page 25. We are justifying the circular issued by the 164 Lord.
Which page?
Starts from page 21.
Yes, you are reading which paragraph?
25.6. I'm not troubling to read everything. Just what I'm stating earlier, Lord, that is not extensive.
What is the internal page?
Internal page not it's super my count 21.
21.
Page 260.
Yes, 260. Yes.
28.6 Lord.
Yes.
What I've stated that has been explained Lordship as to consider and pass on.
All right.
It's in the page 264 Lord. Hence.
$264.
Yes. Hence, the above it's clear that the service by web grant, mineral exploration of and mining rights most appropriate fall under the codes 999
Yes. Yes. That's all.
Yes.
Your Lordship, the first piece, Your Lordship may recall that order and my counter may be relaxed.
We will try.
Yeah.
And one thing, Lord, I have to add, Lord, in the circular, Lord, it is specifically mentioned that the is applicable. No, Lord, sorry, it's not.
Yes.
The Lordship's permission, Lordships. I mean, 27112 appear for the department, my lords. Lordships, I draw your Lordship's attention.
You are representing whom?
CGST, my lord. Central GST.
Yes.
27112 of 2022. If your Lordships have the writ petition copy, I will draw your Lordship's attention to the adjudication order, the order in original, where this issue which has been right now raised by my learned seniors and responded by the councils for the department and the central GST regarding the rate of tax, my lords, the whole dispute is whether it is 5% or 18%. The whole bone of contention is whether it is on the basis of the right of the taxable event being the lease of services.
27111. Which one? Which?
That is the third one, my lord, third writ petition, third sub-item. Since, my lords, I cannot make out a better case on what has been passed by the adjudicating authority.
Just a minute, just a minute. Which page?
No, after this.
My lords, I'll read out from the order in original.
After that.
Order dated 15/7/2022.
Just sir, we are.
I'm sorry.
The list is in 15 pages.
Okay.
Of only this batch of cases. Yes.
My lords, the contention is that the rate of tax is 5% because it involves mining lease, the taxable event being the mining lease. But in reality, my lords, what has happened is that the assessee is getting a license to explore mineral rights over that which is covered under the residual entry under 28/6/2017. Lordship, that aspect has been dealt by the adjudicating authority in the order dated 15/7/2022. Without taking your Lordships to other parts, I'll bring your Lordships to directly to that relevant portion at page 213. of the writ petition, how they have arrived at this calculation of 18%, and what is the relevance of the GST Council recommendations of the 45th GST Council. GST Council recommendation, my lords, the Honorable Supreme Court has in Mohit Minerals and in VKC Footwear has clarified that it has binding value because it's a constitutional body, because it involves an element of cooperative federalism. Therefore, it has to be acted upon only by abundant caution, as clarified with retrospective effect. But as far as, my lords, the issue that is before your lordships is concerned, is 213 lordships may have 11, para 11. Lordships have it? 213, my lords, that internal is 37. Of the order in original.
Para 11.
Well, it's para 11, my lords. This has been copiously relied upon by the department in its counter. So I will not trouble your lordships to take to the counter. I will refer to that portion of the adjudicating order. Lordships, I may place, my lords.
Yes.
Coming to the issue whether the license to extract mineral ore and right to such minerals extracted is a leasing or rental service, it's clear what is supplied by the government is a lease of the right and use mineral ores, and that is not covered by any specific entries in serial number 17 of the notification, and hence falls under residual entry. Up to the amendment of notification 2017, dated 28/2017, by notification number 27/2018, dated 31/12/2018, that is a disputed period, my lords. The tax rate for the above service was fixed at the rate of tax which was applicable on the supply of like goods involving transfer of title in goods. In this case, there was a transfer of title in goods involved in the activities of the applicant, and that was of the extracted mineral ore on which the royalty was paid, and hence the tax rate applicable on this service is the same rate as of tax as applicable on the mineral ore. In this regard, we draw attention to the provision of entry 2A, Schedule 2 of CGST Act that involves land and building, any lease, tenancy, easement, license to occupy land is supply of service. This is the relevant part, my lords, 11J. After the amendment of notification, the notification that we read out, a leasing or renting has been placed under item number 7A, and a separate item number 8 was carved out for leasing or renting services. Leasing or renting of goods was made taxable at the rate of tax applicable on supply of goods involving transfer of title in goods, and all other leasing or rental services was made taxable at 9% CGST. Since the transaction of notice is not leasing of goods, but license to extract and use mineral ore, which involve the license leasing of land, the transaction is covered under residual entries 8 of serial number 17 of notification number 11 of 2017. Central tax dated 28/6/2017 as amended by 27 of 2018, dated 31/12/2018, and is taxable at 9%. So, lordships, I may draw your attention to that notification right away. That is annexure number 2 of the petition, my lords. So, lordships may have page.
License to extract and use mineral ore within one leasing of the land.
Yes.
My lords, that the relevant part of the notification, that is at page 88, my lords. So this will fall under the residual provisions, my lords, heading 9997. There's other services and other miscellaneous services, including, my lords, this is other services and other miscellaneous services, there's a semicolon, my lords, and other miscellaneous services, including services nowhere else classified.
Yes.
Because that was followed by the 31/12/2018, where it was specifically classified, and the GST Council recommendation of 45th Council recommendation, my lords. I'll take your lordships back to that particular page, my lords. I was reading 2214 of the adjudication order. So, my lords, this rate of 9% was always there as a residual entry. Subsequently, the lot of
19.
My lords, at 28/6/2017. I'm sorry, my lords, 2017. That was falling under residual entry.
Yes. Yes, please continue.
Yes.
Please continue.
Yes, my lords. So thereafter, my lords, the GST Council in its 45th Council recommendations has made it clear that this was always there, that 9%, that which is CGST and SGST of 9%, 18% was always there. Subsequently, it has been clarified and GST Council has made it clear, my lords, by its 45th Council recommendation, my lords, at page 214, that has been relied on by the authority. Further, the issue, my lords, have 11K, my lords, for that order in original. My lords have that 214, which was reading out, my lords.
Yes, you are referring to which page?
My lords, page 214, my lords. That part I was from the adjudication order in original.
Paragraph.
I was at 11J, my lords. I'll continue from 11K, my lords.
Yes.
Further, issue of services by way of grant of mineral exploration and mining rights was examined by the GST Council. Lords, may I submit that GST Council recommendation, my lord. GST Council is a constitutional body under Article 279A. In Mohit Minerals, the Honorable Supreme Court has said that the recommendation of the GST Council is the source and power of the principles laid down in the GST Act. Mohit Minerals and VKC Footwear, the court has held that the recommendations are binding in nature.
No. Recommendation. See, the council may have constitutional status, but under the constitutional scheme, it has the function to recommend. Whether that recommendation is binding because it is a constitutional body is a question. So is this your submission that whatever is recommended by the council is binding on the government?
I felt short of clarifying. In fact, what the GST Council has said is not said something new. It has only clarified what has been the position all throughout. That is what has been happened in the 45th Council recommendation. I will crave liberty, my lords. I will place on record.
That is different. That submission is different from.
So what is sought to be argued is that GST Council said something new. So a new substantive rights.
No. There's no question of new. The question is that, see, there are notifications issued.
My lords.
Now, the GST Council has, on the basis of recommendation, this notification has been, this circular has been issued. So whether the recommendation of the council was binding or something could be done with the CA, something was done which the CA GST Council did not intend to do.
They have only clarified what was the position all throughout. That's all. That's my submission. I'll place that relevant part. The issue of services by way of grant of mineral exploration and mining rights was examined by the GST Council in the 45th meeting held on 17 September. In this regard, CBIC has issued clarification regarding applicable GST rates and exemption on certain services. Relevant portions of board circular dated 6/10/2021 are reproduced as under. Have been examined by GST Council in the 45th meeting. The issue-wise clarifications are given below. Services by way of grant of mineral exploration and mining rights. Representations have been received requesting for clarification as to the rate of GST applicable on supply of services by way of granting mineral exploration and mining rights during the period from 1/7/2017 to 31/12/2018 with effect from 1/1/2019. The rate schedule has been specifically amended and it is undisputed since that such service attracts rate of 18%. Therefore, my lords, the issue is settled by the GST Council that the rate is always 18% right from the beginning. It was only clarified as abundant question, ex abundant quarterly, my lords. The GST Council had made it clear that it is 18% was in the beginning, and it was only clarified again by the 45th Council recommendation, the 7th September 2021. Relying on this, my lords, the department has, because it is a taxable event in the nature of licensing of the exploration of rights, the arguments ought to be made that there is a lease of the land, so the rate as that with the transfer of land is also to be made, that rate is to be made applicable. That is not entirely correct, my lords. Therefore, that measure of tax was clear. Subsequently, it was clarified. Therefore, the rate of tax has to be 18%. And this circular has never been challenged. The rate has never been challenged. And rate, my lords, rate is a policy decision, it's a fiscal policy of the government. If they have to challenge that, they have to raise it and to show that they are not coming within the purview of that. So the purview is very clear that it is a licensing of mineral exploration rights.
All right. Yes, we will see. That's all, Mr.
I want to say a few things subject to lot.
See, Mr. We are making it clear that we have not formed any opinion. So please don't go by our observations. If you, Mr. Mahapatra, if you want to add something, it's a different matter. Otherwise, we have concluded your submission on that point.
After plank of my submission, my lords, I may be permitted to file a short written note of submission.
Please do that. Please do. Yes.
Honorable Lord, Chief Justice, permission 2 minutes only.
Just a minute. Let me. Yes, your submission is over. This is what you wanted to submit?
Yes, ma'am. My lord, with regard to contents of my learned brother's that.
No. Are you going to add something to what has already been argued by Mr. Sridhar?
A few points only. I'll take.
Please.
Otherwise, Mr. Sridhar may also thereafter I will submit some supplement.
Thereafter you will do supplement.
Yes, ma'am.
All right.
These recommendations.
Yes, Mr. Kar, you are appearing.
Look, sir, I'm covered by whatever Mr. Sridharan has argued.
Very good.
And there's another writ petition where I filed an amendment regarding to include the adjudication order. I challenge the notice. And
we may be deciding on the question of law, and we will leave other aspects to be decided by the appropriate
basically,
forum.
if your lordship will decide what my learned senior Mr. Sridharan has argued regarding retrospectivity of 18%, that will cover my issues also.
And their submissions also. We cannot ignore their.
That is the central issue, my lord, with your
Yes.
5% versus 18%.
Yes. Yes, Mr.
Lordship, I always believe state is always fairer than the center. Lordship, State Council said is 5%. Personal opinion.
No.
I'm joking, right? Lordship.
I'm ready. I have no authority to consider.
That is not binding on us.
I wanted to say slightly differently, Lordship. My
My lord will take all the blame. Last time your lordship was saying that your lordship will take.
All right.
So my personal opinion is something else. My department, I am appearing on the departments who have to argue, and I will rely my counter.
Yes.
The recommendation, they are saying GST Council recommendation, etc. The notification, statutory notification of 1st July 17 is also on the recommendation of the council. Kindly note that. What they want is internal decision that please tax all services at 18% unless specified otherwise. That's a policy decision. Policy is translated into statutory notification of July 17, and that is also on the recommendation of the council. What they say is, in November 16, much before GST was enacted, we took a policy decision on goods will attract 20% tax and service will put 18% tax. Okay. But then when they issued the notification, for some services at 5%, some services at 18%. In 2019, they say out of some of the services which you put at 5%, we want to put it 18%. We have absolutely no problem. The notification is also recommendatory. The question is whether an in-principle decision will prevail or a statutory notification issued again on the recommendation of GST Council after the principal decision. And even if it is wrong, a correction will be retrospective or prospective. And when your correction notification says this notice will be effective from 1st January 2019, Lordship, the notification says effective from 1st January 2019, they could have said this is effective from July 17. I have no problem. They did not say so because under section 9(1), they have no power to issue notification retrospectively. The power itself is not there, support legislation. Forget about this thing. And as my lord pointed out, ambiguity is created by them. If there's an ambiguity in a taxing statute relating to levy of tax, it will resolve in favor of the assessee. Therefore, first point we say, the notification, statutory notification are also on the recommendation of the council. First para says so, if your lordship sees at page 79, which is the notification, we prescribed 5% tax. at page 17 of my writ petition, Annexure 2, notice 11 of 2017.
Yes.
In exercise the powers conferred under subsection 1 of section 9, subsection 1 of section 11, subsection 5 of so and so, central government on the recommendation of the council on being satisfied necessary in the public interest, hereby notify the central tax to be so and so. This notification is also statutory notification issued in 9-1 as opposed to their in principle broad policy decision. In principle broad policy decision November 16 has to give way to subsequent statutory notification again on the recommendation of the council. Second, subsequent amendment notification says effective from January 2019. And the last point the Lordship telling is, kindly come to page 91 of my writ petition, serial number 35, which my learned friend referred to. Kindly come to page 91, serial number 35 of June 19 notification. It is for other residuary services. When mine is leasing is specifically mentioned earlier in serial number 17, serial number 35 will apply for other miscellaneous services not elsewhere specified. There they put 18% tax. Kindly note that serial number 17, Honorable Lord Chief Justice pointed out, is specifically for me. There the rate was 5%. My learned friend Mr. Mahapatra for the revenue very artfully said, sir, there is an 18% rate. The 18% rate is for all other services not specified above. That's for residuary. And even after the amendment, I was not put in the serial number 35. I was put in 17 only.
No, in fact, this is exactly what Mr. Mahapatra is arguing. That it falls in residuary category.
Lordship, even today, assessment order doesn't demand under that. Residuary category is 9997.
No, even in the, if we carefully go through the circular, the circular which you are challenging,
Lordship, yes.
That is the reasoning which has been assigned.
Lordship, no, it says, see the circular. Circular says I am 9973. Okay. But it says there is an ambiguity. Kindly.
No, the circular doesn't say that you are 9973.
Lordship says that. I'll show that to Lordship. I'm grateful to Lordship. Para 9.3.1.
Yes.
9.3.1. Lordship, see that? As regards classification of surveys, it is recommended by the council that service by way of grant of mineral exploration mining rights most appropriately fall under 997337. The Lordship has got that?
No, but it then clarifies.
It clarifies.
Fall under the council's service by way of grant of mineral exploration.
Lordship, yes.
Not lease. There is difference between exploration and what you do.
Lordship, absolutely right. Next, that is, Lordship, kindly see that one. I will read again. As regards classificator service, it is recommended by the council that service by way of grant of mineral exploration mining rights most appropriately falls under service code 997337, that is licensing services for right to use minerals, including exploration and award. This
and
is the
evaluation. This is the services of exploration and
Lordship,
evaluation.
Justice, my admiration for your Lordship is always increasing. Your Lordship is 100% right. But the assessment made to me, against me, is under this heading. The demand notice today, your Lordship is absolutely right. I am not on the correctness of that. Your Lordship asked me a point, what does the circular decide? Your Lordship didn't ask me the circular decides correctly. There is a difference between the two. Your Lordship, what your Lordship is saying is correct. Today, the demand against me is under 997337 in the impugned show cause notice, impugned order, and the circular. Okay. So, what my learned friend is showing 9997 is residuary. That is never their contention. Even in the circular, even in the show cause notice, even in the assessment order. I don't know whether made myself clear.
And then 9.3.2 Roman 2.
Lordship, I'll get that. More importantly, GST Council in 14th minute held on 18th and May 19, 2019, after January 19, while recommending rate schedule of services 5, 12, 18 and 28, specifically recommended all residuary services would attract GST rate of 18%. Residuary services. Mind they put a specific entry 17.6 for leasing and rental services, 5% as applicable to the goods. Residuary will be 18%. Not all services will be 18%. Today, the hundreds of services will at 18%, 10%. So kindly do. More importantly, GST Council in 14th minute held on 18th and in May 2019. This actually should be 17 lots. 2017 is a typing mistake. While recommending rate schedule of 5, 12, 18 and 28, specifically recommended all residuary services would attract GST at the rate of 18%. In the notification, for me, serial number 17, sub-item 6, 5% is specified.
So, but what is this 15.5%?
That was, Your Lordship, pre-2017, service tax is levied at 15.5. What they are saying is, earlier I was levying 15.5, I would not levy anything lower. What their 9.3.2 says, there is a mistake in our statutory notification. We should have put 18% in July 17. We corrected in January 19. There is a mistake. They say there is a disconnect. That's what Your Lordship says. Many a slip between the cup and the lip. They thought in their mind that I should put 18%. When they issued the notification, they put 5%. And when they corrected it, say effective on January 19. And what they say is go by intention. Lordship, one constitution bench judgment on intention in taxing statute. Your Lordship knows it very well. In my compilation, page 116. Page 116 at page 121. In a taxing statute. At page 121. 1970 Supreme Court. 1968 SCC online. At page 121.
Yes.
About 10 lines, 12 lines at the top of that page. It is well established that in a taxing statute, Your Lordship has got that?
In
page
121.
121, Your Lordship, in the compilation.
Yes.
It is well established, about 10 lines, 12 lines at the top of that page, Your Lordship, just before the extract, 7, 8 lines before the extract. It is well established. About 8 lines before the extract.
About 8 lines from the top.
Lordship, about 12 lines on the top, 8 lines before the extract, Your Lordship, roughly about.
All right, yes.
It is well established. Your Lordship has got that?
Yes.
With the Lordship's permission. It is well established in a taxing statute, there is no room for any intentment, but regard must be had to the clear meaning of the words. The entire matter is governed wholly by the language of the notification. If the taxpayer uses the plain terms of the exemption, it cannot deny this benefit with calling in it any supposed intention of the exempting authority. If such intention can be gathered from the construction of the words of the notification or by necessary implication therefrom, the matter is different, but that's not the case here. In this connection, we report the observation of Lord Watson and so and so. Intention of a legislature is a common but a very slippery phrase, which popularly understood may signify anything from intention embodied in a positive enactment to speculative opinion as to what the legislature probably would have meant, although there has been omission to enact it. In a court of law or equity, what the legislature intended to be done or not to be done can only be legitimately ascertained from what it has been chosen to enact, either an expert's word or by reasonable and necessary implication. It is an application of this principle the statute notification may not be extended to meet a causus omissus. As appears the judgment of Privy Council, we cannot aid the legislature defective phrasing of the Act. We cannot add and amend by way of construction make a deficiencies which are left. Learned counsel for the respondent revenue is possibly right in his submission. The object behind the notification is to encourage actual manufacturing and handloom clause to switch over to power looms by constituting themselves into cooperative society. But the operational notification has to be judged not by the object that the rule-making authority had in mind, but the word which has been employed to effect its legislative intent. They say so in specific circular. Our intention always has been to levy at 18%. The circular, the main reason is we always intend to levy 18%. I will look at the statute gazetted notification or some minutes of meeting. I will be governed by gazette notification. And when they amend it, they say effective from January 19.
Yes.
Lordship, we say in our Vishnu Sahasranam, Karanam Karta. That is, Lord Vishnu is the one who creates pain and removes the pain. Here, Your Lordship, they create the ambiguity and say, I will solve the ambiguity by why? By punishing you retrospectively. It's an indirect tax, Your Lordships. Where is the question of? Only he can be both. Creator as well as a destroyer. Normally, you can do. And the Lordship, and the plain meaning, And as I said to Lordship, it is one pocket to another. Whether I pay under this hundi or that hundi, it makes no difference. Ultimately, government gets. I pay 5 rupees on the input and balance in the output. If the input is increased, output will be reduced. So it's entirely futile exercise. Not one penny anybody gains except the lawyers. Absolutely, Lordship. No, I cannot. Lordship,
Then it is not
tax statutes for a public purpose. They have to raise the revenue. When they collect this way, I mean, brutally frank, Lordship. I have no nothing there. It is entirely revenue neutral. Absolutely no question. What you pay, 20 rupees in the output, 5 rupees in the input, you pay 5 in, as mining rights and 15 rupees in the ore. If you increase the 5 to 15, ore rate will come down. So government gets the same money, same month. I can't even imagine there's a deferment of tax. Not even a deferment of tax. Quantum of tax is same, it goes same government. It doesn't go to different governments. I don't understand why there is these disputes.
Your Lordship, with great respect to my learned senior, it is, Your Lordship, I appreciate it is a case in favor of the revenue, but due to some error, Your Lordship might have just imagined of 2016 when the GST Act has came into implementation and that all the indirect taxes have been subsumed. And that period and what was the difficulty in case of legislature, Your Lordship, to implement such a act, to take all the acts into consideration. And this is a case, Your Lordship, some favor, Your Lordship, in favor of the department revenue, because it is the revenue, and Your Lordship, how that has been
because that pays us also.
So prospective, Your Lordship, just imagine, Your Lordship, so there is a loss of revenue.
Lordship, Lordship, for 30 seconds, I will just take a Lordship's time. Lordship, in the WPC of Tarini Minerals, where my learned senior was arguing, there's a scheme of classification of services that has been mentioned, my lords, in the Annex of 1. I have a portion of that. So at serial number 257, my lords, there is a reference that 997337 that says is licensing services for the right to use minerals, including its exploration and evaluation. And I have shown you, lordship, that licensing services are falling under residual entry and attracting 18% tax. So the whole argument that is the leasing of minerals falls flat on that score, my lords, because the specific entry of classification services is available and there is a specific provision under residual entry for attracting 18% tax. 9918 central GST and state GST, my lords.
But I only request my learned friend to show the entry under demand is raised in the impugned order. The entry raised is not what my learned friend is saying.
My lords,
in the show cause notice, order and circular 99737, that's where I have put. So where is the question of it being at any other entry? In the 99733 is what a show cause order circular says. A case is not like a bottle of wine which gets better as it matures. Justice Krishna says, case is not like a bottle of wine which gets better as it matures. My learned friend is wanting to put some other reading.
I referred only to the
order. Justice Krishna said this. Case is not like a bottle of wine which gets better as it matures. He must stick to Mr. Mahapadra.
In Mohinder Singh.
Mohinder Singh is later, lordship. Justice Krishna in 76 Supreme Court says, it's not like a bottle of wine which gets better as it matures. I'm of course a teetotaler, lordship. Mr. Mahapadra must stick to the entry which the show cause and order says. It's always a great pleasure and privilege, lordship. In fact, there's other issues on validity of the act, lordship, that is not raised in this petition. I was keen to address my lords on that. That will be in some other petition.
How long will this continue? So this
is over, Lord. This matter is over. These matters
are over on this.
So far as this rate of tax is concerned, so far as rate of tax is concerned in the retrospectivity or prospective.
That is the only
question. That's the only issue.
A batch of returns. The other batch?
The other batch, my lord, as I was coming up to your lordship, it's a different matter. It would involve interpretation of the judgment rendered by the Constitution.
Which Constitution?
My lord, the recent one.
Which case is that?
Well, mineral area development.
We will take up your man. Take up your.
In fact, there is a
all cases except your. All cases.
5794 of 2020. It is listed, my lord, but it has got nothing to do with this tax.
No. This is 2 issues involved.
Oh,
yeah, 2 issues involved. What I have changed.
My matter.
5794 of 2014.
24.
No, ESL.
Rate is not involved.
No, rate is not involved.
Rate is not involved.
Levy of royalty and retrospective.
Rate is not involved.
Retrospective is not there.
Only levy of royalty.
Only it is after the 31st.
Only by the GST on royalty.
So
That is the issue involved in my.
Only that is levy pursuant to that Supreme Court judgment.
That I will make
Except that WPC 5794 of 2004.
5794.
Great.
Your name, please.
But this is Abrutosh Mujumdar.
Another two. Another two matter in the last of the list, 1758, 1758 2024 and 17529 2025. These are also 1819 and 1920.
17529.
17528. 1717491 and 17399.
Oh, okay.
These two matters are 1920 and 2021. So 31st 12 2018 after only levy. So these two matters may be tagged with ESL.
Tagged with?
That matter which has been detagged here.
Tag with this one.
Mr. Sinha.
5794.
17491.
Where is Mr. Das?
Yes, ma'am.
You are there.
Yes, ma'am.
You are Mr. Mahanti.
Yes, ma'am.
He has 4 matters. Out of 4, between 2 matters.
2 matters.
17491, 17399.
ये दोनों हाँ ये 3 17399
Excluding
so they will be listed
And your lordship, some of the matters, the 1819 period, inclusive pre-amendment period till 31st 12 2018 and January, February, March in
Then
some
we will
cases.
take up the matter tomorrow again.
Your lordship.
You just give us the list of cases which are squarely covered by the submissions which have been advanced today, and other than those. So tomorrow. Otherwise,
the chart by tomorrow.
matter should be
Item 1 and 2. Necessarily, I paid for time and this is also covered by.
only tomorrow. Tomorrow, just give us.
What?
You are in which matter?
Sub-item 1 and 2.
So your case has been argued.
your
But mine
your
was
case
passed
has
in order.
No, that we have recalled.
We have a little bit of solution.
your name will not be
Malad,
your name you are Mr. Sahu.
Yes.
My lord is gracious.
No,
We want submission, my lord. Is it your lordship desire to take up our matter, which is different, tomorrow or any day,
we can take up your matter tomorrow.
My lord, any day next week, subject to your lordship.
Huh?
My lord, I leave it to your lordship. I leave it.
No, when?
My lord, any day next week or week after. My lord. Week after would be very convenient. My lord,
All
subject
right.
to your lordship's convenience. My lord, I
All
will
right.
not- Any day, my lord, subject.
Please, Alexander, list these matters on. Let the matters be dealing from the present batch of cases and be listed on 1 week. When?
26th or 3rd
2nd December.
Monday.
2/12/2024.
Great from man. So
Be
great.
taken up at 2 p.m. They will start.
To be taken up at 2 p.m.
Forward. Or some other time you can give.
I will not-
Achha, 2 p.m.
Other
case है ना?
matters tomorrow. Huh? 3rd December. 3rd December.
Third year lordship, I had some other prefix matters, your lordship. Today those matters are there. I have taken adjournment for this matter. So
Third-
any other day not.
Third, you can manage, Mr. We will see.
Or we fixed to
It's a fifth case. 5th December. It will be my satisfaction.
5th.
Then fourth.
Grateful, Your Lordship.
Fourth.
At 2 p.m.
As you know, only third I have
2 p.m.
2 p.m.
Fourth, 2 p.m.
4 p.m.
Your Lordship. Grateful.
My lord, subaltern to your lordship. I will few things supplement your lordship. Subaltern 3.
You can give your notes. Written notes. What do you want to say?
I want to say that, my lord, the revenue contention that I am covered under residual entry 99997. My lords, all the services are classified under Chapter 99. Chapter 99 itself will be classified in 5 sections. Section 5 consists of construction services. Section 6 consists of distribution services. Section services, leasing services. Section in production services. Section 9 is miscellaneous services. So we want to cover the entry of Section 9 into Section 7, Your Lordship. So the entry of Section 935 cannot cover under Section 17, Your Lordship. Entry 17 related to Section 7 and entry 35 related to Section 9, Your Lordship. So entry of Section 9B cannot be brought into force for Section 9 and there is no residual entry. My lord, with regard to services concerns, there is no residual entry in all subservices.
The difference between you and me is that you remember all the provisions, and I'm very happy the way you have presented it, but I don't.
My lord, the residual entry is with regard to services.
Just give short notes. I will tomorrow, and
he wants even 5 is not payable, Your Lordship. That's what he says. Even 5% need not be paid.
That is 5%. Residual
also permitted to file a short
notice.
notice.
After 2019, Your Lordships, in services.
I may be also permitted to file a short
please
notice.
give the chart tomorrow.
Thank you.
Lordship, great privilege, Lordship. Great pleasure and privilege.
And please make available the chart to learn Mr. Mahapatra and others also, so that there is no
These matters will be coming up tomorrow.
confusion. Yes, tomorrow.
At 2 p.m.
2 p.m. Just for 2-3 minutes.
Common order, you write that these 3 are defect, will be listed on charge. So इधर है ऊपर लिखता है that item Tarini is there, give the number, they will write it as the lead.
The other matters will be on board tomorrow.
Yes, all the matters will be board on tomorrow except those 3 items. And we just request all of you to give us a list, a chart of cases which are squarely covered by the submissions which have been advanced. So we shall address only that legal issue in our judgment.
I am not on these.
Other matters today.
Yes,
yes.
We'll take up. We have 10 minutes.
No, not today.
We can take up now. Yes.
We should rise.
It will be tomorrow.
No, do you want us to rise? Because now it is. Take up.
Grateful.
Lordship kindly. Thank you.
Any argument we can ask?
Yes. Next.
Item number 9.
This petition is ready for application of the amendment to the case of the petitioner, Your Lordship. Lordship had directed the opposite parties to take an instruction.
This is regarding what?
Your Lordship, there was an anomaly in the recruitment rule, which was subsequently amended. And our prayer is to make this amendment applicable to us. Your Lordships have decided it on this matter. And my prayer is that we should be covered on that same.
Yes, they said that. Is that what, forest or something?
My God.
Huh?
Yeah.
So why will they not apply?
But need your Lordship's direction.
Do you have the judgment?
Mine. I've given it. It's there in there.
8/10/2024, we had asked you to take instructions because he had specifically stated it is covered by that WPC 12179 of 2023. That is why the matter was adjourned. Yes.
Your Lordship passed the order. The only point is the conservator forest recommended that the period of service, that is the period of training rendered by the LO taken into consideration, and during that period, they will, instead of being paid stipend, they will pay the usual salary applicable to their. And accordingly recommended to government to bring out the amendment, and government, that is the recommendation 2018, and that proposal was accepted and government came forward with the amendment 2024. His representation has only been rejected on the ground that since the amendment is Prospective 24, it will not be applicable to them. But the conservator forester clarified that in other states, similar officers are getting the benefit what they have claimed. That the service period is treated as, for the service period, stipend period will be treated as service period, and during the training period, they will be given the benefit salary. That's all over India, that scenario is.
Now, things are clear.
70 paragraph 6 here. Oh. So paragraph 6 of the judgment is also applicable to him.
And the necessary alterations.
The petitioner was appointed as forest range officer. Was appointed as forest range officer, which is a group B post regulated by.
The corrected thing which will apply to him.
Oh, wow.
That necessary changes. There's a mistake in paragraph 3, rule 13.
Same judgment needs to be
adopted. Rule, you said it's not rule 15, it should be rule 13.
My lord, yes, rule 15 is for the rangers. We are.
Okay. So there is no mistake, only the applicable rule is rule 13. Okay.
I've made the necessary alteration.
All right. No, we have to know what is the alteration without following blindly.
Forest range officer, which is a group A, bracketed junior.
Assistant conservator.
Group A.
Junior.
Bracketed junior branch post, regulated by Odisha Forest Service. Group A, recruitment and condition of service rules, 2013.
Just 1 moment. So foreign range officers is a group A junior branch. And you have not corrected that. First line of paragraph 2.
Forest range officers. Assistant conservator of forest range officers.
Please read also.
They were.
I'll give a new one.
They were required to undergo training for period of 2 years in the forest college to obtain, that is must be degree in forestry.
Diploma in forestry.
In diploma in forestry. Stop. Rule 13 of the said rules reads as under 13.
Identical as rule 15.
Right.
6 rule है थोड़ा देख दो.
In the present writ application, the petitioners have put to challenge validity of rule 13 of the rules to the extent the same provides for grant of stipend only in place of salary for the training period, and the effect of sub-rule 6 of the said rules, whereby the period of training is not to be taken into account for computation of period of service. So stop. It appears that the state government, it appears that the state government has amended Rule 13 of the said rule, while Odisha Forest Service Group A Junior Branch Recruitment and Condition of Service Bracketed Amendment Rules 2024.
Annex 12.
There are two amendment rules.
11. And with the issuance of the said amendment rules, comma, Rule 13 of the rules has been amended by notification dated same 13/3/2024, published in the official gazette on 15/3/2023. 24, wherein it has been provided that the finally selected candidates shall be required to undergo 2 years training in a recognized forest college to obtain diploma in forestry, and during the training, the trainee shall be paid salary and other allowances and admissible from time to time. So stop. Next, it appears from the subsequent amendment that the petitioner's grievance of these petitioners as raised in the present writ application stands redressed. So stop. Next, when counsel appearing on behalf of the petitioner has raised an apprehension that the petitioner may be denied the benefit of Amendment 2024 made in 2000.
That was the apprehension that your lordships disposed of in that matter. My petition is that in our case, we had already pursued this matter since 2018, and they were under contempt to consider our case. At that time, they amended the rule. Our prayer is that in the light of your lordship judgment, the same application may be made to us.
In view of a similar issue had arisen before this court in case of Priyadarshini Sahu and others versus State of Odisha, bracketed WPC number 12179 of 2023, in relation to similar rules, namely Forest Range Officers Group B, namely Odisha Forest Service Group B, bracketed recruitment and condition of service bracket close rules. The said petition, in view of similar amendment in the said rules, has been disposed of by an order dated 6/5/2024. So we are of the view that the petitioner's case is squarely covered by the observations made in the said decision in case of so and so. So the writ application stands disposed of accordingly.
Item 29. I have received an affidavit. You have also may grant me one time so that I can give a reply.
29.
29.
Who is there for the other side?
My friend was there, but now he's not there.
You're the applicant?
I'll intimate him. I'll intimate him.
Fresh admission.
Fresh admissions will come tomorrow.
And Miss I have admission.
And others on next week.
And item 38 is
What's the urgency?
He will let you know.
and item 38 will put high count on item.